Miami Code to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property as observed and cited by a code enforcement officer of the city. If the city is not able to prove the case, then I will dismiss it and you may leave. These proceedings are being recorded, so all persons who are speaking should do so one at a time so that the testimony is clearly audible on the record. If English is not your primary language, then please inform me when I call your case, as we have translators who will assist you during
recording in progress.
When your case is called, the property owner, agent for the property owner, and any witnesses that you may have should announce your presence. And when asked, please speak directly into the microphone and say aloud your name, your business, your mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware of and understand the violation that is being heard today, and if you understand what is required of you to resolve the violation. The city will present the case first, and then the property owner, violator, will be given an opportunity to testify on their behalf, to bring forward witnesses to testify, to present evidence and photographs, and to cross-examine the city's witnesses. Following the case presentation, I will issue a finding of fact on the case. If I find that a violation of city code exists or existed at your property, then depending upon the case, I will set an abatement date for the violation to be resolved. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table the case until another hearing in the future. If you do not agree with my findings of fact or ruling, then the property owner may appeal this administrative order that I issue on this case to a court, to the circuit court. An appeal must be filed within 30 days of the date of the execution of the administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim record of the proceedings. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant. And it is recommended that persons who plan to appeal their cases should provide their own court reporter at these proceedings. Pursuant to city code, the city of North Miami, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. At this point, I believe that the police officer present will administer, will do the pledge of allegiance or the swearing in of the witnesses, which?
Yes, well, we can do the pledge and then we'll swear in all parties.
Okay, let's do the pledge.
Are we ready?
Yes.
Okay. I pledge allegiance to the flag of the United States of America and to the republic
for which it stands,
one nation, under God,
indivisible,
with
liberty
and justice for all.
At this time, if the city staff can stay with their audio and their video on to be sworn in. Any staff giving testimony?
Okay. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
Can we have the translators, please?
Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say I do.
I do.
Thank you.
You may disable. Clerk, are you there? Okay.
Good morning, everyone. And thank you for participating in today's special magistrate hearing. I will review the process by which today's hearing will be conducted. Make sure your device is muted at all times unless you are giving testimony on a case. If you are using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed into Zoom, you will receive notification giving you access to audio and video so that you may give your testimony. If you are physically here and wish to give testimony, you must sign in with the code clerk and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code compliance office to be provided access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click the raise hand button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist you during your case, please indicate that when your case is called. Your magistrate, that concludes the instructions for today's hearing. And as far as for any deletions on today's agenda, it's item number 27, Leo Paul Manuel, case number CERCV 2022-00186. That case has been postponed.
That's case 27?
Yes.
Okay. Anything else?
That is all the deletions for today's hearing. And to proceed with, I can proceed with the first item.
All right, if we're ready to proceed, call your first case.
I'm going to go ahead and proceed with item number 16, Frey, case number CELDR 2022-0009, and the officer is Shanna Sanders.
I have an Amita Frey here on behalf of this property. If you would just enable your audio and video.
Amita Frey, are you here?
I am here. Good morning, Magistrate Smith.
Good morning. I see you and I hear you loud and clear. You need to be sworn.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? If so, help you God, please say I do.
I do.
Okay, again, for the record, please state your full name and home address.
My name is Amita Frey. I am the homeowner of address 12900 Northeast 4th Avenue. I am also an attorney.
Okay, do you know why you're here?
I do.
Okay, have you had a chance to look at the code violation that was issued against the property?
I have, extensively.
Okay. Before I allow you to present, let me hear from the code officer, Shanna Sanders.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a case for property address 12900 Northeast 4th Avenue. This falls under the violation of the land development regulations. It was first initially observed on April 19th of 2022, whereas I received an email referencing some trees and landscaping that was placed along the swell. Upon visiting the property, I sent the notice to the property owner. We have had back and forth conversations along with our third-party company Triage, who does arborist duties and things for the city. In short, he's been informed as to what he needed to do to rectify the planting situation that's going on along the corner of his property. From what I spoke with the third-party company, an application has been submitted on May 23rd of 2022, but as of the 23rd of May, no movement has been made with the application. I have had no further conversations with the property owner. I've had conversations with the third-party company stating that there has been certain situations with the property owner due to illnesses and things of that nature. He's stating that he would move forward with providing the necessary information that the company was asking for, but as of my last reinspection on the 18th, there has been no further notice or conversations regarding rectifying this situation. The problem here, he has trees along the swell area that needs to be trimmed down, cut down, proper placement of them. But again, he has been directed on what he needs to do, but has not taken those necessary steps to do so.
Okay, let me understand some basic facts before I turn it over to the property owner. The swale area depicted in the photographs is owned by the city, correct?
That is correct.
And the city allows, under the land development regulations, for a process to obtain a landscaping permit, correct?
That's correct.
Has the property owner applied for a landscaping permit?
He submitted an application on May 23rd, but from the application in or from the third party company, the application was not filled out in its entirety. They have certain things that they require that needs to be included with the application, and that wasn't submitted completely.
Okay, so where we are at this point is that the property owner is in the process of rectifying the situation, but evidently he's a bit late. Let me hear from the property owner.
Okay, thank you, Magistrate Smith. What Officer Sanders said there at the end is inaccurate. Actually, I did submit an application which was not referenced in the code violation. Simply put, Magistrate Smith, I'd like to just very quickly give you a history and walk you through this. I have been actively engaging and cooperating from the very beginning regarding this situation. I can tell you that initially I was given a code violation notice quite some time ago, which referenced a very different code, which had to do with nuisance. This nuisance code had to do with keeping your property in a particular condition, not allowing it to be unkempt, having disabled cars. I wound up sending Officer Sanders a very lengthy email asking her to clarify because I did not understand the code that she cited did not coincide with her notes. Her notes very specifically reference a visibility issue and a site issue and a safety issue on the swale. Now, to be clear, I've only owned this home for about 1.5 years now. I am not responsible for many of the plantings here. There was a couple who owned this property shortly before me. The issue here, Magistrate Smith, is that the city has failed completely in their duty to advise me of exactly how I'm not in compliance. They have never referenced any kind of code that is accurate or appropriate. The current violation notice, the only one that is active after I advised Officer Sanders that the code was inaccurate for the prior notice, She withdrew that notice and filed the current notice, which is the notice we are here for today. It's citation or case number CELDR 2022-00009. Now, the code referenced in this particular notice, which is 29-5-1205, simply states that I must submit an application. Now, Officer Sanders just referenced, I don't know where she got it from or how or why, because nobody has ever advised me that my application is somehow incomplete. I can assure you that I have a copy of the application here, which I'm happy to share. It was included in an email with Officer Sanders and I assume a subcontractor, Triage, who handles these things for the city. The application is complete. There is nothing missing. Neither Officer Sanders nor Triage ever told me that there was anything missing. The only thing I've been cited for is not retroactively submitting a permit, an application for a permit. I have since done that. I have complied with this code violation. Nobody at any time has given me any code that I am in violation regarding any kind of visibility or safety issue. That's number one. How can I possibly comply with the city when I have asked repeatedly, and I have emails, which I'm happy to share my screen if you would like to see them, Magistrate Smith.
Not necessary.
I very clearly lay this out and request from both Officer Sanders and Allison, who is the person working for Triage, to please direct me to either the city code, county code, state code, or federal code that they're referencing, which is specifically the issue they are requesting from me is not to submit an application or comply with the application requirements of section 29-51205, which I have. My application is complete. It is signed, notarized. I submitted affidavits. There is not a single thing missing from my application, nor has anybody even advised me that it was deficient in any way until I just heard Officer Sanders mention that. I do not believe that's accurate. I don't think if you review my application, that's accurate. I have complied by submitting the application. Nobody has shared with me when I asked Triage to share with me the code that they're actually citing me with. She told me she did not have time for that. She only worked at the city for a few hours a week, and this was not part of her purview. And to date, I have yet to receive any kind of code violation that references exactly what Officer Sanders keeps referencing, which are her notes saying that there is somehow created some kind of sight or line visibility issue. That is not what I am cited for. The current citation specifically references my requirement to submit an application, which I have now complied with. What happens from there on is up to the city. The city has not submitted any kind of formal request from me to follow up. They have done nothing other than tell me to remove trees and given me no basis for such a removal. They have not cited to any kind of triangle of visibility or any kind of code within the city, county, state, or federal. And lastly, Magistrate Smith, I'll try to make this brief. It appears to be a very selective enforcement. I've taken photos and I advised Officer Sanders of, even within a 4-block radius of me, much more egregious examples of plantings on the swale that extend far beyond mine, that are much more obstruction problematic, which I also have photos of that I'm happy to share my screen of now. So frankly, I am at a loss. Nobody has explained to me exactly why they want me to do what they keep telling me they want me to do, nor have they properly cited me with any kind of code violation notice that conforms to what they're asking me to do. I have complied fully with this code violation notice. My application is complete.
All right. This is really not brain surgery, guys. This is very common in most cities. Folks that want to use their swale that belongs to the city typically have to file an application, and the filing of an application on its terms will tell you exactly what it is that is required as part of that application process. I'm not gonna, go into the weeds to see if, you crossed every T and you dotted every I, but at some point, every city will require an inspection by whatever means are designated in the code to ensure that the improvements on the swale, as beautiful as they may be, are acceptable within the guidelines of the city. And this is a zoning violation, so I assume that zoning might weigh in on whether or not your application is sufficient, or if certain things have to be moved around. And so I'm going to ask the city attorney to explain to us what the process is so that the property owner is aware of what it is that he needs to do. Has he complied by filing the application, or are there other actions that need to be taken either by the property owner or by the city in order to allow the property owner to receive the permit that he needs in order to have these improvements on the soil? And by the way, most of these permits that are issued, because the city owns the property, they are revocable. This is not and I don't know, maybe the city attorney can explain it to me, but in most cities, these permits can be revoked, for any reason. So, Madam City Attorney, tell us what the requirements are to move forward.
Thank you, Honor. Just to respond to the comment about improper notice, I just wanted to, for the magistrate to take judicial notice of the notice of violation, which is attached to the agenda packet, which rightfully has the land development regulations section, which is being discussed this morning, section 5-1205 of the land development regulations. Yeah,
I'm aware of the citation. I know what section it cites, and it has nothing to do with views, visibility, or any kind of
exactly. Exactly. And if you look at that section of the code, it is quite extensive. The first part of it does require a permit application to be filed. But when you go further into looking at what that permit application entails, it requires a landscape plan that also is inclusive of a vegetation survey,
including
location and graphic representation, tables, irrigation plans, drip line encroachment.
All included.
Yeah, please, Mr. Frey, let the city attorney speak, and then I'll give you an opportunity. Don't interrupt her.
So in looking at that extent of materials that need to be submitted with the application, it also, by definition, has an extensive review process. So the majority of these landscape applications go exactly as you indicated, Magistrate Smith, where you may submit your initial application, you may get our tree arborist to come back and say, look, you need to modify your landscape plan. The location of this tree maybe needs to change. Maybe the species of the tree may also need to change. So there is usually a dialogue going back and forth between the property owner and the zoning department and the tree arborist before a final plan is approved by the city and ultimately a permit issued. It appears that final part, the permit being issued, is what has not occurred yet, and that's why he's here this morning.
Okay, Mr. Frey, I am prepared to give you as much time as it is necessary.
I'll be very brief.
No, not for your speech.
Well, no, I would like to respond.
No, you can respond, of course, but in terms of complying with whatever the city has as the regulation that applies to this application, I'm prepared to give you a reasonable amount of time to, obviously the city will have to cooperate with you, but it seems like there may be a lack of communication or a failure of communication, because if you're not in government, a lot of these things are not easy to appreciate. So whatever it is that you and the city need to do in order to get your permit, I'm willing to give you time, but go ahead and,
Yeah, I appreciate that, Magistrate Smith. There seems to be a disconnect here, and it's very simple. I appreciate the city attorney chiming in. However, she has once again neglected the very simple thing that I am requesting of the city and why this notice of violation is deficient. The notice of violation was issued to me because I had not submitted an application, period. That was the issue. The relevant issue to that notice of application was something called safety and visibility. That has nothing to do with this code violation at all. I have asked repeatedly, you mentioned yourself, Magistrate Smith, earlier, that there are guidelines that we must comply with. I am happy to comply with any city code, any county code. I worked in government. I worked for the EPA. My background is in horticulture. I have a master's of science in horticulture and landscaping. I can tell you, I am happy, absolutely overjoyed to do anything that is required by the code. Nobody has given me a single guideline. And I apologize, but there is a reason that laws exist and codes exist, so that some person who works for a company named Triage can't come along and arbitrarily say, I feel like you should move this here, and I think you need to do this. And you know what? I think you should put a 40-foot tree there. I have no problem. If I need to put a 40-foot tree somewhere on my property, fine. Show me in the code what the guidelines are. Tell me why my plants are causing some kind of violation of city code. And again, Magistrate, this has nothing to do with what I was cited with. My application includes everything the city attorney just referenced, and it's not complicated. It's actually a very simple application. It's only 4 pages. I'm happy to review it with you. It includes a very detailed...
We don't have time for that.
I understand. It includes a very detailed site plan. It includes species of trees, location of trees, location of irrigation. I have complied fully. This notice should be dismissed. Now, if the city has another issue with my violation of a safety or visibility sightline, please send me a notice of violation with the code specifically referenced so that I may gladly comply and move the trees.
That's not relevant to these proceedings because you were not cited under any of those provisions.
Absolutely.
Madam City Attorney, does 29-5-1205 deal with the landscaping permit for improvements made on the swale?
Yes, section 5-1205, by definition, the title says landscape plan and permit required. That's what the city takes issue with. There is an application that's been submitted, but it's not been an approved application. A permit has not been issued yet to say that the landscape plan has been approved by the city's zoning standards and as well as the city's arborist.
Again, though, that's not a violation. I have not violated. I have complied with the code by submitting the application, which is complete. It is now the onus is on the city. Now, if your application is complete, can you please provide us with your permit? Do you have a copy of it that you can show us? I cannot issue myself a permit. Now, the reason the city has not issued a permit to me is because they say that my trees have violated another section of the code which has to deal with safety and visibility. That has never, ever been given to me. They cannot arbitrarily withhold a permit based upon a violation of a separate code that nobody has ever even given me. Please tell me, why is my application being denied?
Magistrate, if you can, I see that the building official has his hand up, but if you would like, I'll make sure, if you want to give a short abatement, I'll make sure to reach out to Triage myself, as you all have been discussing. I've been looking through my emails. My latest email shows on the 2nd of December, I specifically reached out to Triage as well as city staff and community planning and development, Paula Viola, who stated, again, the application was submitted on May 23rd, but as of then, they have had no further contact with him. It has stated they have reached out to him. He has had different personal situations, whereas he has not responded. He did ask for an extension because he was supposed to go before the magistrate, a few months ago, but he asked for an extension. So some type of conversation has been going on. But what we can do, if you don't mind, I'll ask for, I don't mind giving a short abatement, possibly give an extension so that I myself could reach out to Triage to see maybe if they need to, relay some type of messages to him, if they need to relay it to me to relay to him, as in what steps need to be taken. But, even as our city attorney is stating, an application has been submitted. So somebody knows something as to what needs to be done. I don't know where the lack of communication is coming, because I've had emails back and forth with Mr. Frey. It has been 3-party, even 4 parties, along with our lead code officer, with our director, with Mr. Frey. It's just, the ball has stopped rolling since May, and we need.
Okay, I don't want to go back and forth. I don't want to go back and forth anymore. Okay, these permits, and in some cities, like my own, they're called a revocable permit. And it's totally within the discretion of the city to either accept or deny or accept with conditions. The city must have certain conditions associated, consistent with this particular code section. We're talking about this section. We're not talking about any other section. So whatever the city routinely looks at to determine whether or not the property owner is entitled to this permit, you all need to work out. And
Absolutely.
I'm gonna give you all 60 days to work it out, and decide. And if the city requires that certain trees be moved or cut down or whatever the requirement is, if it's a requirement of the code, it has to be complied with.
Absolutely.
But I'd like the parties to get together and work this out, because we shouldn't be here discussing this.
Your Honor, I would very much like to comply with the city's code. I would just like to be told what it is. Like, tell me, give me measurements so I know this tree can't be here because of this code violation. That's
okay.
it.
Well, it should not be the unfettered discretion of the third party.
Correct.
Tree arborist. The city has to also make a determination as to whether or not this particular plan, this landscaping plan that you're presenting, is consistent with the city's zoning code, and that's all the city that's the only issue before the city. Crystal, you wanted to say something?
I just want to make clear and put on the record that the arborist is not arbitrarily making any decisions on behalf of the city. The arborist works in collaboration with the city as an expert as to, determine, the nature of trees and, things of that nature. With respect to Mr. Frey's questions, those questions really need to be directed to the zoning department, to whom which he has submitted his application. They are the ones who are qualified and prepared to issue any permit if there will be a permit issued. But as it stands, Special Magistrate, we bring the case before you today, requesting an adjudication on behalf of the fact that the trees were planted on public right-of-way without a valid permit.
Who at planning and zoning?
That was my next question.
No, who at planning and zoning?
He would need to be in contact with her name is Paola Valla in planning and zoning. She is our sustainability administrator.
Can you spell her name for me, please?
Sure. What we can do, I'm happy to do, is if you want to hang around, we can put all that information for you in the chat, so that the magistrate can rule. We do have a pretty heavy agenda, but Shanna, please put her information in the chat for him.
I will. I have his email. I'll send it right to him after we log off with this call.
Thank you, Officer Sanders.
All right. Based on the testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violation of 29.5.1205 exists on the property for failure to timely file for a landscaping permit, I find in favor of the city, enter an adjudication and set a compliance date of 60 days. 60 days to comply. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Your Honor, just for the record, the violation I was cited with was failure to submit an application, which I did timely. That's it. Nothing else.
Yeah, but you did the work before submitting the application.
I did not, Your Honor. This has nothing to do.
The prior owner did.
Yeah, which means that I'm being punished for doing what I'm supposed to do under the code, right?
Well, that's not how it works here. If you own property and there's a violation on your property, regardless of how it got there,
I am required to submit a retroactive application, which Officer Sanders advised me of, which I did timely.
Okay. If you comply within 60 days, the fine goes away. There is no fine.
I have complied. I submitted the application. That's what the violation notice is. How can I comply again? Resubmit the same application?
Let's not figure out how many angels can dance on the head of a pin. The violation was there when you acquired the property, right?
No, it was not. It was not. No, it was not.
When did you landscape the swale?
I did not. I'm telling you. There were trees that were placed on the swale. I was issued a violation notice long after I purchased the property, many months after. The violation notice I was issued told me I have to submit a retroactive application, which is legal under the code, for approval of those plants that were put there before. I did that timely. I was a few days late because I was in the hospital. How do I comply now with the code that I've already complied with? Comply again by resubmitting the exact same application?
No, the city's going to get back to you and tell you whether or not the landscaping is appropriate.
But I agree with you, and I appreciate that. But how can I be guilty? How can the fine be adjudicated against me when I've complied?
I don't want to rehash it. There was a violation on the property, whether you were responsible or the prior owner was responsible or the trees grew by themselves.
There was no violation. The violation was a failure to submit an application, and I was given the opportunity to comply by retroactively submitting an application, which I did. I complied. I complied with the notice.
Mr.
You know,
Frey,
if there is compliance, which means that there has to be an inspection, and the city issues the city issues the permit, then you're home free. If the city does not issue the permit for a non-valid reason, if they just won't do it, then we'll talk about it in 60 days. But right now,
how can we, Your Honor? Because you've just said that I have to pay a fine after 60 days if I don't do whatever the city says, even though I've already complied.
Because you're now on notice that the application process has not been completed and you have not been issued a permit.
But it's not up to me. It's not up to me. So if the city takes more than 60 days, I automatically have to serve.
No. If the city, if the city in bad faith does, which I don't expect they will, but if they don't issue you a permit within 60 days without good cause, then you're off the hook. Okay.
That's not what you said, Your Honor. You said I have to start paying a fine after 60 days if I'm not in compliance.
Well, at the moment, you have filed an application, and the city is now going to determine whether that application is full and complete and whether a permit issues. So if the city doesn't do that, then I will toll the time until the city does it.
Well, I would ask Your Honor then to not make a ruling today because I think it is unfair because I have complied and the ball is in the city's court. And if they don't comply, I'm on the hook for a fine. And how do I, how do I come back to you? I can't set a hearing before you. That's up to the city as well. It's not fair.
Well, yeah, you cannot be fined unless it comes before me. So it will at some point come before me if there's no compliance. So right now, I would urge the city and the property owner to work together to get the permit finalized. And that's all I'm going to say on the matter. I know you're not happy with the fact that I find you guilty, but I'm not fining you. I'm not issuing you a fine until and unless there's 60-day period within which this issue can be resolved.
If you read the code, Your Honor, I am in compliance, period.
Okay.
I'm not guilty of failing to comply with the code.
I have to accept the interpretation of the city code as determined by the city attorney. I don't have the authority to overrule the interpretation of the zoning code as determined by the city attorney.
So can the city attorney just clarify that I am in violation? Please.
I have to determine that you're in violation because the trees were there before the permit was sought.
But that's not the issue. The issue was a failure to apply.
Okay. I'm not going to go further. I've given you plenty of time. You are on notice that you have 60 days and the city will work with you to get you the permit. And
I literally can do nothing. I'm sitting on my thumbs.
Okay. You have to do something because right now, you were already advised by Ms. Patterson to go to the planning department, planning and zoning, and they will walk you through the application process. Just filing an application is not compliance. You have to have a permit, and you don't have a permit.
But that's not what I was cited with.
You've said it 3 times. I'm done. Okay? If you don't like my ruling, you're a lawyer. You know what the next step is. You were fined. You were found guilty. You were not fined. I'm giving you 60 days to work with the planning department to get your building permit issued by the city. If the city doesn't issue it, I'll hear it in 60 days. Okay? Done.
Sure.
Next case.
I'm going to proceed with item number 8 and 9, which Anna Holiday and Norman Holiday and Don Holiday. Item number 8, case number is CEBPR 2022-00472. The officer is Gennaro Murillo. And item number 9, case number is CERCV 2022-00272.
All right, there are 2 cases. You want to hear them together or separately?
We can hear them together because it's.
No, the question is directed to the city.
Oops,
Okay.
sorry.
Yeah, we could do it together.
Okay, so let's
Please raise your right
start
hand.
let's start with number 8, but before that, we have to swear in the witnesses. Go ahead.
Can you vote? Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. You say I do.
Okay.
You guys were on mute.
I do.
I do.
Okay. All right. Case number 8, an after the fact building permit for a new driveway. Let's hear from the code officer alleging violation of section 5-32.
Good morning, Officer Murillo from the City of Miami Code Compliance. On March 31st, 2022, I found a violation while patrolling on the property address 820 Northeast 143rd Street. Issue a notice of violation to obtain an after the fact building permit for a new driveway. On April 26th, I received an email from Kimberly Hernandez from one general contractor about a permit that was going to be submitted to the city. I issue a 20 days extension. On June 15, another 3 months extension was given from a call received from Anna. I did the inspection on September 15. There was no compliance and no permit was submitted. On November 19, I posted a notice to appear for today's hearing. And as at my final inspection on December 2nd, 2022, there was no compliance and no permit was filed in the city.
All right. Let me hear from the property owners. Please identify yourselves and tell us who do you represent or what property do you own?
I'm Anna Halliday. I'm the property owner of 820 Northeast 143rd Street, and this is my husband's.
I'm Spencer Schwartz. I guess I'm testifying as a witness.
I'm sorry, I heard different names.
I'm Anna Halliday. I'm the property owner as of November of last year of 820 Northeast 143rd Street. And this is my husband, Spencer Schwartz.
Okay. The property records reflect a Norman Holiday also being an owner.
Yes, that's my father.
Okay.
He doesn't live here, but he co-signed with us on the.
Okay. Do you concur that a violation exists on the property and that it has a new driveway without permits?
Yes.
How much time do you need to get an after-the-fact building permit, do you think? You have somebody working on that already?
Yes, and the only reason it took this long, I just wanted to provide a little background, was because the work was done before I purchased the home. So I purchased the home with a 365-day conditional reoccupancy agreement, which I extended before the expiration. But we had an agreement with the previous owner who did the work before he sold me the house that he would complete the permitting since he had all the information and specs and everything. And after issuing him numerous extensions, he failed to do that. So we closed the contract with him and I took over the process in September. And since then I've obtained the architect. I have all the architect drawings, just waiting to sign with a contractor today to submit the permit applications.
Okay, how much time do you need?
It's 3 months. Is that reasonable? Just for all the processing time and everything?
Yeah, because you're dealing with building issues, and I know how long those may take. You may get some comments from the building department and have to revise certain things. So I'm going to give you 90 days. So let's deal with this case first, and let me enter an order that based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication, and set a compliance date of 90 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Okay, and is that fine absolutely going to be assessed even if we've made a lot of progress in our demonstrating?
No, that's not how it works.
Okay.
You have 90 days to complete the work, and then if you don't complete the work within 90 days, then the case will come back to me, and based on the facts and circumstances at that time, I will either ratify the fine and the fines accruing, or give you a little bit extra time based on good cause.
Okay, thank you.
So we'll, hopefully you can get everything done in 90 days. And if a problem arises and you can't complete it, and you're acting in good faith and moving along, and you're just maybe a few days, before you get your permit, then come back and talk to me, and we'll see what happens. But right now, during that 90-day period, as long as you comply within that 90-day period, you will not have a fine.
Okay, thank you.
Okay, let's hear the next case. This is about a boat.
On July 12, 2022, while patrolling, I observed on the property address 820 Northeast 143rd Street, a boat on the property. A notice of violation was issued either to remove the boat or apply for a variance. I had a reinspection on June 22nd where there was no compliance. A notice to appear for today's hearing was posted on November 19, 2022. I had a final reinspection on December the 2nd, 2022, and there was no permit that day of my final inspection.
Okay, Mr. Schwartz, Ms. Holiday, is it Holiday?
It's Holiday. Whatever.
Okay, it's just spelled a little different, maybe. No. Anyway, what's your position on the boat matter?
So the variance was submitted to code compliance day before yesterday, and I paid the administrative fee for the variance. And we have the record in evidence, and code compliance should have it too. So the application is pending.
You were granted a variance, or you applied for a variance?
I applied for it. I'm sorry, I misspoke, and paid the associated fee.
Okay. Let me ask the code officer or Crystal, in a single-family neighborhood such as this, are these variances difficult to obtain? Are they spinning their wheels, or how difficult is it to obtain a variance?
There is some criteria, and there are some guidelines that they will need to meet in order to qualify for the variance. It is available for them in a single family, and it appears as though they would be eligible to receive one. However, I can't guarantee that they will have it. So, if only an application has been submitted at this time, I think that we would continue to take the position that, that the city would request an adjudication and give them the time that they would need to go through the application process.
Okay. Mr. Schwartz, you understand that it's uncertain whether the city will issue a variance or not. It's up to whatever board issues variances.
I understand.
The zoning code, and if you do not get a variance, the boat will have to be removed. I agree with Ms. Patterson. We will adjudicate you guilty on the vote because you started storing the vote without the variance. But again, I'm going to give you 90 days to go through the variance process, and we'll see where we are then. So based on the testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 90 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Okay, anything else from the owner?
Yes, I just have a question because we also received violation notices for our AC units, which are part of, we're doing the permitting process for everything all together. And so I just wanted to check on the status of this violation and if there's a new court date for this one.
That's not before me today, but if you would like to ask Code separately, maybe Code can give you an answer right now, maybe not. Code?
Yeah, I posted a notice of postpone. So right now, because you have applied for that, so you will receive a new court date soon if it's still not issued the permit.
Okay.
Yeah. Hopefully you'll be able to work it out before the next magistrate hearing. Okay, thank you. Let's move on to the next case.
I'm going to proceed with item number 21. Harry Potvin, sorry if I'm pronouncing your name wrong, and wife Oriette, case number CEVPR 2022-00398. This case was previously found guilty with an abatement date of December 2nd, 2022. Fines set at $500 plus $100 cost assessment, and the officer is Aaron Barber.
Anybody here for the owner?
Yes, there's an Orette. Orette, are you there? If you can enable your audio and video, please. Orette, are you there? Can you enable your audio? There you go. You just need your audio now.
Ma'am, please raise your right hand.
All right, let's swear her in.
Please raise your right hand.
You need it?
Do they have any translator?
Yeah.
Asian, please.
Bonjour, madame. Levez mes doigts, s'il vous plaît.
Bonjour.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Est-ce que vous jurez solennellement que tout témoignage là, c'est vérité, seulement la vérité, rien d'autre que la vérité, que bon Dieu vienne en aide? Dis oui, d'accord?
Oui, oui, d'accord. Yes.
Yes, I do.
Ma'am, please state your full name for the record and your home address.
Madame, dis tout nom, s'il vous plaît, pour enregistrement avec adresse Kaiwa.
Orette Potvin, adresse Caron, c'est 1250 Nord-Ouest, 126e Street, Miami, Florida, 33167.
Tout à l'heure. Et 1250 Nord-Ouest?
126e Street.
Mm-hmm.
Miami, Florida, 33167.
Do you understand the nature of the violations?
Est-ce qu'on comprend la nature violation?
Moi, pas de comprendre. Pas de comprendre. C'est un monde qui te fait l'autre côté, dans l'autre adresse là. Et puis, moi-même, pendant que tu as fait, je fais pour moi tout.
Well, I did not understand it. I did not, but someone was doing it at a different address, and I had them do it for me too.
I think I'm going to die right now.
Okay. Do you understand that you were found guilty back in October and that you were given until December the 2nd to secure a permit?
Non.
Est-ce que vous comprenez que vous êtes joint coupable et en octobre et vous êtes jusqu'à 2 décembre pour te sortir en permis?
Moi pas de joindre notice. Moi pas de joindre notice.
Oh my God.
C'est
I did not get the notice.
All right, let me turn to the city and ask the officer to respond to the notice issue and tell me a little bit about
Oh my God.
the work that was done without a permit.
Good morning, Erin Barber, City of North Miami Code Compliance. As noted, this case has been was previously adjudicated. The violation was opened in early March of 2022. The notice of violation letter was mailed out on March 15th, mailed certified to the property owner. In addition, notices had been posted at the property for the violation for the previous court notices to appear, and notices have been posted and mailed certified to this property owner.
Okay, and
can we allow the translator to translate, magistrate, please?
Yes, please.
OK, nous gagnons Erin Barber qui c'est représentant et accord et alors responsabilité code et pour ville Nord Miami et dossier ça il était jugé déjà auparavant et dans commencement mois mars 2022 et il y a une notification qui a été envoyée par mail certifié et le 15 mars et il a été envoyé déjà plus il y a une autre notification qui a été déposée dans l'adresse là la propriétaire directement concernant l'autre rendez-vous pour apparition qui était faite déjà et plus notification certifiée qui a été envoyée par mail là.
Bon, moi, pas de joindre certificat. Par contre, si mais celle ça te joindre, c'est avant. Ça a gagné à peine 4 jours comme ça. Maman qui se de aller dans plastique, les joindre sachet dans plastique, tant qu'on il connaît que qu'importe papier que vous voyez by moun comme qu'on fait en publicité. So lui-même il dit il vient comme travail 7 jours, qu'on y a la vini avant hier, les mal la caille moins il dit que même je non sachet non papier que City envoyé ban moi. Mais il comprend ses réclames. Like tant que vous voyez pour tout le monde, c'est les mauvais moi ouais ça. Puis qu'on y a là mon vini mon travail avec lui, moi vini trouver lui, me dit qu'il parler avec lui.
Well, I didn't get them. The only thing I received was about 4 days ago, and it was my mother. From my mother. She went outside. She found that plastic bag with the paper in it. She thought it was paper ads, and because I worked 7 days, and when she came to the house and when she went outside, she found a plastic bag. She told me that she said, "Here's a paper I found in a plastic bag outside that came from the city," and I brought it with me at work, and that's the only thing I've ever received.
Okay, ma'am, who is Harry Poitevin?
Et qui est-ce qui Harry Poitevin?
C'était Marim.
That was my husband.
Yes,
he passed away.
I'm sorry to hear that. Ma'am, you've the problem that I have is that you've already been found guilty of doing work without a permit. You still don't have a permit for the driveway, do you?
No, moi pas connais moi pas connais si vous me prendre permis pour ça because me pense c'est tellement petit, c'est parce que l'homme monte pas que machine non et puis va tomber parce que gagne un pied bois from the city qui fait asphalte là getting higher, so every time on besoin monter dans driveway il doit pas tomber. Alors m'ta pensé mettre wash but moi next doit après le faire un bagage là et puis moi dit why don't you faire pour moi tout, so m'pas connais si c'était un bagage because it's tellement small, it's pas un big thing that I don't even recall combien était chargé pour faire li.
Special Magistrate?
Yes.
I mean, I guess translator, if you could just translate what she just said, and then I'll.
Well, I did not know I needed a permit for that because it was something small. The thing is, when you park your car there, someone come and park, it would fall because there's a tree on the side from the city, and it made the sidewalk seems high, looks high, and so I thought I would put some rocks, but then I saw the neighbors next door. They were doing some work, and I said, "Why don't you do the same thing for me?" But I didn't know I needed a permit for it.
All right, Ms. Patterson, what is your recommendation on this one?
I'm going to ask that we table the item, Magistrate. We're going to reach out to her, the building official, and myself. She's going to need to remove what was placed. I'm not confident that she was here for the initial hearing, and if she's saying she didn't receive the notice, I'm not sure why. But if we can table it for 30 days and allow for an opportunity to speak with her on what she needs to do to come into compliance.
Okay, that's a great solution. I think that she needs to understand what needs to be done, and I don't think that we accept her testimony that she didn't know anything about it, that she wasn't.
I would just ask for can you just ask her for her telephone number, please?
Ou capable ba nou numéro téléphone, s'il vous plaît.
305 728 92 31.
305 728 9231.
Okay.
So is the city
we would just ask the table.
The city's recommending, well, yes, we're going to table it, but is the city suggesting that the improvements are going to be removed?
That's what we're going
to. Or is the city insisting that she get a permit?
We're going to. She won't be able to get that permitted, and based on what she's explaining on how it was done, and we're going to attempt to explain to her that we just need to have her remove it, and if she's looking to actually have it done or have the entire approach paved, we'll explain what that process looks like.
Excellent, good solution. We'll table it until the city brings it back, if it ever comes back.
Do I have some time to interpret all that to her?
Yes.
Thank you.
She understands.
Pas question?
Ou comprendre ça que t'es dit ou bien vous voulez m'expliquer ou?
Pas fin comprendre ça l'autre mon nan dit. But moi besoin connaître là dit pour remove li. Est-ce que vous still besoin permis pour remove li ou bien ou juste ou pas besoin vous just craser. But si ou pas voulez remove li. So,
ou pas quitter les gens liés. Ou pas quitter les gens liés.
Donc, il faut faire l'autre monde vient faire li.
Ou a besoin pour un contracteur pour le bien fait. Mais quand il y a gens liés, s'il y a pas bon permis pour les comme ça.
So, okay.
Okay, but we'll talk to you offline. Na palabra, na puedo après ça pour nous fin parler.
Okay, the city is going to work with you, ma'am. Thank you very much. I'm sorry about your husband, and we'll work with you to make sure that you're no longer in violation.
Nous voulons travailler avec vous sur ça. Merci un peu. Désolé encore pour Mario. Et donc, il a expliqué tout ce qu'il y a pour faire pour retirer tous les problèmes ça, sortir là-dedans.
M'ka sorti sur Zoom, non? M'ka sorti?
Yes.
Oui.
M'ka sorti, ouais? Okay, merci beaucoup.
Thank you
so much,
everybody.
Bye.
Thank you.
Bye.
We now proceed with item number 23, K&H Holdings, Miami LLC, case number CESTA 2022-00061. The officer is Jose Perez.
All right, anybody here on behalf of the property owner?
I think I'm the delay here. Michael Tobin and Cody McCalkin, maybe? And I'm so sorry if I'm mispronouncing your name. All right, so I see Cody. Michael Tobin?
Cody McCon, yes. Michael's here.
Sorry about that.
He should be popping in a second.
I don't see Michael logged in. So are you the property owner or?
We are attorneys for the property owner.
Understood. Do we need to wait for him, the other person?
Yes, if that's possible. He should be in already.
So I don't have him signed in.
Let's give him a few seconds. If he's not in, then we'll move on to the next case.
Andrew Atkins. Okay, so I have an Andrew Atkins. Andrew Atkins. Could that be it, Cody?
Andrew Atkins is the attorney for the tenant in the property.
I see. Okay, so I'll give him access.
And the
I have
property
another Cody.
is here as well. His name's Mark Hackham.
Okay. I have a Cody. Oh, maybe you gave him your link, so maybe this is him.
Oh, that might be why I can't get in.
I'm giving access, so he just needs to accept. Okay. And then Andrew Atkins, I'm also giving you access into the meeting. And you said the property owner was what name? I'm sorry.
Okay, Mark Hackham is the property owner.
I don't see Mark signed in.
Hello.
Hi.
That's him. Yeah.
Oh, this is Mark. Okay.
Hi,
Do you
how
mind
are you?
renaming yourself, please, sir? Can you just rename yourself?
Yeah, Mark Hashem.
Okay, I'll do it. Hold on.
H-A-C-H-E-M.
I still don't see the other attorney, so.
Ms. Patterson, I'm here for the tenant, Andrew Atkins. Thank you for letting me
Understood.
in. My client is here as well because we'd like him to testify. His name is Corey Rankine, and he registered.
So guys, I don't have Corey. I don't have Michael.
And there's also a court reporter.
Okay. I don't know that I need to give the court reporter access. I think they can view, right, Jen?
That's probably right. Yeah.
The court reporter's not expected to testify, so
Right.
She can record it from viewing.
Right.
But,
Okay. I have an Andrew Atkins here now.
We have two Andrew Atkins.
That's Corey. That must be Corey. I'll tell him to rename it.
All right. So
I
I'll
see
just quickly do that with Corey. And then I think I just don't see a Michael.
Yeah.
I see a Diane Morris.
Can you send another invite to my link to the panel? Michael Tobin's under the same link as me.
No, I'm not able to do that right now. I'm sorry. I can't send anyone any links right now. But
Not a link, I mean invite to the panel to speak.
so I have a Diane Morris. Is that him? So I have a Diane Morris raising their hand. Does anyone recognize that person? Diane Morris, what case are you here on behalf of?
Good morning. I'm here as the court reporter with U.S.
Okay.
Legal.
Thank you.
Yeah, I'm good.
All right. So is this Michael Tobin?
Yes, hi, thank you. I just got in.
Thank you. Do you mind just renaming yourself, sir?
How do I do that?
I'll do it. Don't worry.
Okay.
All right. Is that everyone?
Yes.
Okay. Mark and Corey, please raise your right hand. Where's Corey? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Okay, that's Mark Hashem.
Correct.
Who's the tenant?
Corey Rankin.
And who's Andrew Atkins?
I'm the attorney for the tenant.
Okay.
Special Magistrate Smith,
Yes.
good morning. I'm the attorney for K&H, the property owner, as is Cody. I just want to make sure that you're aware of the litigation that's pending in the circuit court between the property owner and the tenant, and more specifically, the recent court order denying the tenant's motion to appear. I'm not really sure how the tenant got access, but I absolutely object under the order that the court entered to their testifying in any way. If they want to observe, that's fine, but I don't see any any reason for them to testify in light of the court's order.
Yeah, Mr. Magistrate.
Wait. Okay. I have reviewed the court pleadings. I am familiar with the court orders. I do my homework, guys. This is not going to be a trial. This is a very, very simple, run-of-the-mill, plain vanilla code violation regarding short-term rentals. We're not going to get into options for sale, or we're not going to get into eviction proceedings, or the allegations back and forth as to whose responsibility it was and whether the owner gave consent or didn't give consent. I'm not interested in any of that. The only thing I'm interested in, was there a violation? Okay, was there a violation that can be proven to my satisfaction? And then if there was a violation, I will assess appropriate fines based on the representation that the city has made that this is a repeat violation. Now, whether it was the tenant or anyone else, or the broker or anyone else that advertised is of no concern to me. The only issue is, was there an advertisement in violation of the city code? So I want to make that clear, because we're not going to spend 3 hours here litigating your case. Okay? So the first thing I'm going to do is I'm going to have the code officer introduce the case, tell me what's about, tell me what the advertisement said, and does it comply or not comply with the short-term rental ordinance, which is 5-30 parentheses D. I'm gonna give the floor to Officer Perez.
Morning. Officer Perez of the City of North Miami. Today we're hearing the case in regards to the property at 13010 Biscayne Island Terrace. At this point in time, we're hearing this case as a repeat offender because they were previously found guilty in the hearing on October 2021 for short-term advertisements. So at this point in time, it would be considered a repeat offender case. The case ultimately was opened because upon due diligence, the city found short-term advertisements for said property on VRBO. As you can see here, the attachments of the property. So at this point in time, because it is a repeat offender, and we're going to stick to the fact of the matter of the case is, the city is seeking a penalty for the advertisement that was up, even though they were already found guilty of a previous violation of short-term advertisement.
Do we know, Officer Perez, who placed the advertisement?
So whether it was the tenant or the property owner, we don't have that specific. However, here it says it was hosted by Alina. So whomever that was.
Who is Alina?
The city doesn't have any information on who it was.
Okay, and does the advertisement violate city code?
Yes, it does. The advertisement.
Which code section applies?
The code section that applies would be Chapter 5-30, subsection D, which specifically prohibits advertisements of any short-term rentals in residential neighborhoods. Which
for less than 3 months, correct?
That is correct.
Okay. Do you have any knowledge as to whether, in fact, the property has been rented out on a short-term basis since the original violation?
I don't have that specific. However, we do receive several complaints from the residents in the surrounding area for the activity that was going on there. I cannot speak to if it's continued since this violation was opened. However, we have received complaints when this violation was opened.
Okay. And you were the code officer who wrote the violation?
That is correct. I wrote this one and the one that was previous to this from May, I'm sorry.
I believe you said May 7th.
May 7, 2021 was my original violation, which was adjudicated on October 2021. And then previous to that, there was also a short-term rental case for actual rental activity that was confirmed. And that was also adjudicated on October of 2021.
Okay. You didn't cite the tenant, did you?
We cited the property owner.
Okay. And why do you cite the property owner and not the tenant?
because the property owner is responsible for any activity that goes on at the property itself. So we have the authority to cite the property owner because the violation carries with the property, not with the person.
Okay, let me hear from the representatives of the property owner. Mr. Tobin?
Yes, thank you.
Go ahead. Present your case.
Okay, thank you, Magistrate Smith. We're not looking to litigate this case here. We're really just looking to kind of stop the bleeding. As Officer Perez stated, and as the orders entered in the circuit court case indicate, we leased the property to the tenant. The lease specifically prohibited short-term rentals. The reason that we did not appear at the first hearing is we did not receive notice of it. Notice was sent to my client's former attorney who incorporated them. As you know, the address put on the deed and in Sunbiz is where the municipalities will send notices. We never received that because my clients are not in touch with the address where the notices were sent. The notice was also sent to the tenant. The tenant did not forward it to us. That is the reason we didn't appear at any previous hearing. We only received notice from Officer Perez advising us that the tenant had reached out to them and in fact had misrepresented that they represented my client, the landlord. It was only at that time that we became aware of all of these proceedings and reached out to the city and asked to reschedule the first hearing that the tenant's attorney had surreptitiously scheduled. And we're really here to advise you, magistrate, and the city that this is in very deep, protracted litigation with the tenant regarding an eviction and an option, and that these violations were completely caused by the tenant without our knowledge, without our involvement. The property is for sale. We understand that the violation occurred. We are not contesting the violation. The violation is specifically one of the basis for the eviction proceedings underway. What we are asking for is time to finish our eviction and as well a reasonable fine that could be paid out of the closing once the eviction is finished and the property is sold. It is a very difficult situation for my client. The fines on the property that have accrued completely eliminate the ability to sell the property. We can't sell the property anyway until the eviction is finished. We are set for trial, or at least have been advised by the court or ordered by the court to be ready for trial by April. We're ready to go to trial tomorrow. Again, I absolutely vehemently oppose the tenant testifying. I see no relevance. I see no standing. And there's been a court order specifically on this ruling. So, really that's all I have to tell you, knowing that you're familiar with the court proceedings in this regard.
Yeah, well, Mr. Tobin, I did review the file. I did see an order dated September 27th. I don't recall exactly what the terms of that order were, but you're representing to me that the court ordered that the tenant not testify in these proceedings?
The court specifically denied the tenant's motion for an order compelling or providing for them to appear. The judge specifically said it's a public hearing, they can attend, and that basically if the city required or requested their testimony, that was one thing. But the court denied the tenant's motion. If you give me a second, I can actually read the order to you if you'd like.
Go ahead.
Okay. Okay. First of all, Your Honor, Magistrate Smith, what I didn't tell you is that the court initially entered an order on September 27th on our motion to stop the short-term rentals of the property. The court ordered, quote, tenants shall cease all short-term rentals and advertising for short-term rentals for the property located at 13010 Biscayne Island Terrace. Number 2, tenants shall not use the property for short-term rentals or permit the property to be used for short-term rentals. Paragraph 3 of the order says tenants shall not advertise the property for short-term rentals in any manner or on any website platform, including without limitation Airbnb, VRBO. Tenants shall be allowed to sublease the property in compliance with the City of North Miami. And 5, if tenant violates the order, landlord shall be entitled to sanctions as determined. Then on November 21st, just several weeks ago, the court entered an order on the tenant's motion for an order to allow tenants to participate and testify in hearings and matters with the City of North Miami to resolve code enforcement violations. That order says counter plaintiff, who is the tenant, counter plaintiff's motion for order to allow tenants to participate and testify in hearings and matters with the City of North Miami is denied. If the city permits the tenant to testify at the hearing regarding violations pertaining to the property, nothing in this order shall preclude or prevent the tenant from testifying at said hearing. Those orders, I believe, were submitted to the city for this hearing.
Yes, I've reviewed it, and since the tenant is not the violator, I will rule that the tenant has no standing to testify unless you, Mr. Tobin, call him as a witness, in which case he would be allowed to testify. But since he is not the violator charged, then Mr. Cody, the tenant, will not be given an opportunity to testify at these proceedings because I don't think his testimony would be helpful or relevant. I would like an answer, though, from the property owner, whether through you, Mr. Tobin, or through the property owner, as to whether or not some of the allegations made in the counterclaim regarding the owner's knowledge and consent to engage in short-term rentals, whether that is accurate, whether comments were made that North Miami is easy. It's easy to do short-term rentals in North Miami. It's not as hard as in Miami Beach. Whether any of those comments have any truth or accuracy.
Okay, happy to do that, Your Honor. However, I think it's inappropriate for the tenant really to hear this testimony given the order, as it will or might impact the court proceedings. I can absolutely state on the owner's behalf that they did not give any consent. They never said anything to that point. All these issues, though, will ultimately be adjudicated at the trial we have.
Yeah, it's relevant in determining culpability and the amount of the fine that I will be assessing. Obviously, if you're an innocent owner that went to the extent of specifically providing in the lease that no short-term rentals would be allowed, and it made it clear that would not be appropriate under the lease, then I may take that into consideration. But if there is some allegation floating out there that the owner knew about it and approved it and benefited from it and all that kind of stuff, then I may feel differently about the fine that I impose.
I can absolutely tell you that the owner did not agree to it, did not approve it. There is no evidence. There is only the allegation in the pleadings. The lease specifically The lease specifically prohibits and precludes short-term rental. The owner received zero additional compensation. In fact, the rent has been consistent as in the lease from day one. The tenants made a motion and we were in court Tuesday. Their motion was denied to reduce the rent. The rent has been the same as in the lease schedule since day one. No additional money, no money under the table, no wink, wink, nod, nod, no evidence of that except what the tenant is alleging, which is strictly, in my opinion, to gain leverage in the litigation. There is no evidence whatsoever in that.
Okay, are you going to present, Mr. Atkins, I will give you an opportunity to speak, okay? Yes. Just because I've ruled that your client is not a proper party and has no standing doesn't mean that I'm going to shut you up. I'm going to let you speak, okay? Mr. Tobin, do you have any further evidence? I've reviewed everything you've submitted.
I don't at this time, although I would like to hear what Mr. Atkins said and reserve the right to rebut or respond to that, if that's all right.
Absolutely. You may respond. Mr. Atkins, tell us who you are again.
Sure. I'm the attorney for Corey Rankine and Brian Extra. They're the tenants at the subject property. Mr. Tobin said some things that are not accurate, but they pertain to the litigation. So I do believe the litigation is not proper to talk about at this proceeding. So I will not comment on those. All I will comment on is the fact that there's only one person out of all these people sitting here today, not Mr. Tobin, not his client, not anyone else except for Mr. Rankine, who can testify as to these violations, as to whether or not they actually occurred, as to whether or not he's involved in posting them, as to whether or not they've been cured. So for someone to say it's not relevant because the city chose to fine the owner, that's not accurate. Because if you want to find out the truth as to these violations, our witness is here. He's going to tell you that the August violation, he had nothing to do with it. There's people that post this stuff all the time. He's going to tell you the May violation from 21 that the landlord, who did likely have notice of the hearing, chose to ignore and did nothing about it. Mr. Rankine would have loved to have testified today to tell you the May violation was taken down, the advertisement. And that goes back a year and a half ago. And the property's not being rented short term. So to say a tenant is not relevant to a hearing where he's the only one who can provide any evidence whatsoever regarding these violations, Mr. Tobin didn't tell you one thing about the violations. He has no knowledge. His client has no knowledge. We're the tenant in possession. So I believe if Your Honor wants to get to the bottom of this, to call Mr. Rankine and he can tell you under oath what happened with these violations.
Mr. Tobin, you wanted to comment?
Oh, I'm sorry, I was muted. I do want to comment. I don't have any belief or faith in what Mr. Rankine will say for one reason. We are in heated litigation over an option to purchase and an eviction. I believe that Mr. Rankine will testify that the violations were not his responsibility or not his doing, but I don't know, and I don't believe it's appropriate. I do believe that Mr. Atkins and Mr. Rankine want these violations reduced. It's my opinion that it will or may further a potential settlement. I don't think Mr. Atkins or Mr. Rankine are looking for the property owner to be hit with a big fine, because I don't believe that behooves them. But I believe that all of this is inappropriate. However, if Mr. Atkins wants to proffer to me what Mr. Rankine will say, and we then can reschedule, then I'm more comfortable. But with my client here and knowing the extent of the litigation, how many times we've been in front of the judge, how many more times we'll be in front of the judge, and how important this hearing is, I think if Mr. Atkins wants to cooperate with us as to this matter specifically, then I'd be fine going forward at a later date. But not knowing what Mr. Rankin will testify or what Mr. Atkins will say, given the court order denying their motion to testify and given everything, I do not feel it's appropriate to open this up to his testimony. But I am fine hearing from Mr. Atkins after this hearing as to what he will say in regard to my client's liability. It's not Mr. Rankin's liability here at stake. It's my client's liability. So for me to open this up, to this testimony, that seems inappropriate to do.
Go ahead briefly, because I've already I'm ready to rule.
Again, back in October when this hearing was supposed to happen, we put it in writing to Mr. Tobin what Mr. Corey Rankin was going to testify to. We've already done that. We told him exactly what he's going to say, because guess what? If the fines are reduced, if the violations are cured, it benefits everybody. It benefits the owner, who's ultimately responsible. It benefits the tenant, because we're responsible under the lease. So Mr. Tobin is sabotaging the hearing, is what he's doing. I'm glad we have a court reporter. And I did proffer to him in writing back in, tell you the date, October 19th, exactly what Mr. Corey Rankin is going to testify to. And I've even told Your Honor today what it is. That the May 2021 violation was taken down, that ad, that he acknowledged responsibility for it, but that the August 2022 violation was not his doing. I've told Mr. Tobin that. Told him actually on the phone, and I told him in writing. And that's what Mr. Rankin's going to say. If Mr. Tobin has a problem with that testimony, well, you know what's behind it.
All right. Again, I see this as a relatively routine short-term rental violation. It doesn't matter who placed the ad. It could have been a broker. It could have been a friend. Whether Mr. Corey himself did it or Mr. Tobin's client did it, there was an ad placed on the web advertising for short-term rentals. Unless there's some fraud involved where maybe some enemy of the owner posted it just to be vindictive, I find no evidence of that. I find that there is an advertisement on the web advertising this house for short-term rental, and that's all I need to hear. I don't need to hear that somebody didn't do it or this one did it or the other one did it. It affected this property. So, Mr. Tobin, one last comment, and then I'm going to rule.
Magistrate Smith, I really don't have anything further to add than what's been said.
Okay. Magistrate Smith, Mr. Rankin's going to tell you it wasn't a broker. It wasn't anyone with his authority. In essence, it was a fraud. It's someone that we have nothing to do with. But that does make a difference.
Well, it may make a difference in your litigation, and you may be held harmless in your litigation in any event on any fines that may have accrued, or you may resolve it with the court. That's up to you in that trial how you resolve that. For purposes of the city of North Miami, I'm going to find that there's a violation, and I'm going to assess a fine based on what I believe is reasonable under the circumstances. So based on the testimony of the code compliance officer, the photographs, the evidence, the pleadings that I've reviewed, depicting that the cited violation did occur, that it is a repeat offense, even though the owner may not have known about the prior violation, I find that notice has been given. I find in favor of the city, and I enter an adjudication on this case and assess a fine of $2,500 for the violation, based on my authority under Chapter 162 of the Florida statutes. So that's my ruling. I'm ready to proceed with the next case.
Magistrate Smith, how long will we have to pay that? When will we receive a copy of that order?
The order will be received in about probably 10 days, and then you can make arrangements with the finance department or Crystal. Who do they pay the money to?
You can actually contact our office. Our sitting clerk will be able to assist you with that.
Okay, thank you very much.
Okay, you're welcome.
Thank you, Magistrate.
All right.
Thank you.
I'm going to proceed with item number 24 and 25, Kathy Bradley. And case number for item number 24, it's CEODS 2022-0091. And item number 25, case number is CEPFY 2022-00161. And the officer is Aaron Barber.
Rodney Brantley, if you can accept the invitation to join the meeting, please.
Is that Miss Brantley?
Rodney Brantley.
I thought it was Kathy Brantley.
I have a Rodney Brantley here. There we go.
Rodney, please raise your right hand and enable your audio as well. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Sir, again, for the record, please state your full name, address, and your relationship to the property.
My name is Rodney Brantley. The address is 1665 Northwest 130th Street, and I'm the son of the property owner.
The property owner is Kathy Brantley?
Yes, sir.
And you're Rodney?
Yes, sir.
Are you aware of the violations that were issued on the property?
Yes, sir.
Okay. Do you contest the violations?
Just one of them. As far as the vehicles in the backyard, I started with the permit, the building application for the permit.
All right, let me stop you right there. That's the next violation. I'm on item 24, which is the outdoor storage.
Okay, yes. I believe that has been cleared. I was just waiting for Ms. Barber for me to find out if that has been cleared or not.
Okay, let's deal with that. Let me hear from the code officer.
Good morning, Aaron Barber, City of North Miami Code Compliance. These are two new cases. The first case is the CEODS 2022-00091, and this is for the outdoor storage at the rear of the property. This violation was opened back in February, and we did allow the property owner and Mr. Brantley time to remove the items. However, as of the final recheck on December 8th, the outdoor storage remained at the property.
All right.
You see in the photos here, the items that are, this is at the rear.
I saw, and what's the date? December 8th. Okay,
yes,
I saw that picture. I'm going to rule on this one since it's pretty clear that the violation still exists based on the testimony of Ms. Barber, the city's code compliance officer, and the photographs and evidence presented. Proper notice has been given. I find in favor of the city, enter an adjudication and set an abatement date of 30 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Mr. Brantley, you have 30 days to remove the excessive outdoor storage and make it nice and clean. And once you do that, then call the code officer and she'll go out and do an inspection.
Okay, I just had one question because I had a few things out there, and just from my understanding, I thought I had removed everything that she was asking about. That's the only reason why I was just waiting to see was that cleared already, because I did move some stuff from the backyard. I just didn't know if that was enough to clear the.
No, it wasn't enough, and I saw the picture December 8th, I believe, and it shows quite a bit of items, all kinds of stuff that doesn't belong there. It's not sightly. It's not the way that you would want a neighborhood to look. So to the extent that you need to remove more things, you need to do it within 30 days. Otherwise, you're going to have to pay fines.
Okay.
Okay? You got 30 days. Maybe maybe somebody else's storage area. If it doesn't fit in your house, maybe you'll need to take it somewhere else. Okay. Next case is the issue of the, I believe, the lawn parking.
Yes, sir. New case as well. Parking on the unpaved lawn at the rear of the property. This case was also opened back in February of 2022, and as of the final reinspection date on December 8th, there are still quite a few vehicles parked at the rear of the property on the grass on unpaved surface.
Okay, Mr. Brantley?
Yes, sir.
What do you say about that? You can't have a vehicle parked in an unpaved lawn.
Yes,
You
sir.
understand that?
Yes, sir. She explained that to me. That was the first time of me hearing that since the whole time I was living there. But I did start with the permit to try to get the concrete put down. It's just my mother, she's out of town right now, and they explained to me that she needed to be here to put the permit in herself and be notarized, and she won't be here to maybe the end of the month. But I did start. I do have the application in my hand. I'm just waiting on her so I can try to put it in.
You plan on pouring concrete and creating a driveway?
Yes, sir.
You have an architect?
No, all I have now is the permit, and I've been trying to call someone to get a. Who's going
to do the work?
I've been trying to call and get a decent price, honestly.
How much time do you need?
If 90 days is possible, because my mom, she won't be here till the end of the year.
Okay. All right. I'm going to give you 90 days based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 90 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. If you're having any difficulty whatsoever, you speak with the officer and explain to her if you have any problems with the city or with the contractor before the 90-day period expires.
Yes, sir. I've been in contact with Ms. Barber since the beginning.
Okay, great. Excellent. All right. Have a great day.
Thank you.
Thank you.
The next item is item number 29, Noel Apartments LLC, case number MHVIO 2022-00302. This case was previously found guilty with an abatement date of December 2nd. Fine was set at $500 plus $100 cost assessment. And the officer is Gennaro Murillo.
Would we have here on behalf of the property?
They are here in person.
Okay.
All right. Who's here? Noel Apartments.
Sir, please raise your right hand.
Yes, sir.
Please raise your right hand.
Jessica Bezwar.
You solemnly swear or
does he speak English?
Yes, I speak English. Yes, I do.
Okay. All right.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall
Can
be
you
the
speak
truth?
a little bit louder, please?
Can you hear me?
Yes. Go ahead, a little bit louder, please.
No problem. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. You say I do?
Yes.
Please state your full name, your address, and that's it. You can put your hand down. Your name, your address, and your relationship to the property.
My name is Clovis Noel. My home address 440 Northwest 104 Towers. I am the owner of the property 14033 Northeast 6th Avenue, Noel apartment.
All right. You have been cited for doing work on a new window in Unit 4 and other work at the property. Wooden roof outside the laundry room. Do you contest those violations?
Oh, well, apparently, I don't contest anything because I was wrong doing the work without a permit. But apparently, I have a permit in process. I just haven't received them yet. But some of the work already done. Apparently, the inspector aware that the wood laundry already removed. But the window, as far as I understand, there is a permit ready, and the slab already has applied for a permit, but I haven't received it yet.
You have an architect or engineer or contractor working on these issues?
Yes, sir.
And you don't have a permit number yet, a process number, do you?
Not yet, sir.
Okay. Well, keep working diligently. How much time do you need to get the after the fact permit?
Well, it depends on North Miami because we submitted everything, survey, and the after a letter from the engineer. So everything is in North Miami. We are waiting for North Miami.
All right, I'm gonna give you 90 days, but you gotta move quickly because 90 days is just around the corner. Okay?
Yes, sir. Thank you.
Yeah, based on the unrebutted testimony of the city's code compliance officer, the photographs.
Magistrate, it was already adjudicated, so it'll need to be tabled.
Oh, he's already adjudicated. That's right. That's right. That's right. That changes the story a little bit, okay? Because I found you guilty back in October, and I set an abatement date of December 2nd, and today you're telling me that you have filed the plans, but you need more time. I've already set a fine. Based on the fact that you're in the process of getting your permits, I'm going to table this for 60 days.
Okay.
Okay, so 60 days, or else you're going to start accruing fines at $500 a day. That's a lot. Okay, so move quickly, please.
Well, I hope North Miami employee they start moving a little bit faster. The best I can do is submit the paper, but I have no power to tell them to move.
I will tell you that building official is on this meeting. He knows how to do things right. And if you have any problems or any question, he's on the screen right now, and he will address them. But oftentimes, and I will tell you from a lot of experience in construction, many architects, engineers, and contractors will blame the city instead of taking ownership of their own. And I'm not saying your contractor or your engineer is bad. I'm saying that many contractors will blame the city for their own problems. Okay, so if you have a problem, if your engineer, your contractor tells you he's having a problem, you get in touch with the building official and we'll try to figure it out.
Okay, sir.
So
apparently what you say, excuse me to interrupt you, what you say, since I got caught for the violation, I start writing check to all of them. Apparently they take my check and go to vacation. Now I'm going to grab the horn by the bull, the bull by the horn, and make sure that they get here and take care of my business.
Right, and if they tell you something, verify it with the city because sometimes they lie, okay?
You right about that?
I'm telling you, it's what I hear every day. That owner is told by the contractor that the city is being difficult, and then when I contact the city. The city says the contract doesn't know what he's doing.
Magistrate,
So-
if I may just let the property owner know. So your permit has already been approved. You just need to come to the city to pick it up. The case is closed for compliance at this time, Magistrate.
Okay,
Now, which
excellent.
one of the window or all?
It's
permit?
only for the window. The walkway is still pending.
All right,
So he's
thank
still
you.
working on that.
Thank you.
Okay,
Well,
so there's two things on this issue. So you just
Yes.
need to go pick up your permit for the window,
All right, thank you.
and the other item on the case is still pending.
Thank you.
Yeah, there's a wooden roof outside the laundry room.
That has been removed. So right now he's only pending for the walkway.
The walkway. Okay, so you got to deal with the walkway then. Okay,
Thank you, sir. Thank you.
great.
Thank you.
Thank you, sir. Who's next?
Gonna proceed with item number 31, Omega Investors Group, Inc. And the case number is CEMIS 2022-00124, and the officer is Gennaro Murillo.
All right, who's here on behalf of the owner?
Is it Clarissa Burke?
And Louis Carbonell.
Okay.
Sorry, sorry, I was having a bit of technical difficulties. Good morning, everyone.
Good morning.
Clarissa Burke?
Yes, sir.
All right, why don't you raise your right hand and be sworn?
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
Ms. Burke, please tell us your full name, address, and your relationship to the property.
Sure, my name is Clarissa Burke. Our office is located at 1075 Northeast 125th Street. I'm the assistant project manager for the general contractor who's facilitating the construction management of the property in question.
All right, is this new construction?
Yes,
And the owner of the property is Omega Investors Group, right?
that is correct.
And according to the Secretary of State's office, the managers of that corporation are Sebastian Scamilla, Juan Lago, and Sean Chemtov. Is that correct?
Yes, sir.
And that's who the contractor works for.
Yes,
And this is a one-time violation of the code section dealing with working after hours and on weekends, correct?
yes,
And do you contest that violation?
yes, we do.
Okay, then let me hear from the code officer and prove to me that there was work done after. First of all, before I do that, this one is a new one on me. I have not seen this section quoted before during my tenure. Can the city attorney tell me what the section 5-35B says?
1 second, Your Honor, I'll look it up. You said 5-.
5-35 paren D. What are the permitted hours, and on weekends, what are the permitted hours? If somebody from code can answer, I would appreciate a response.
Gladly.
So the code
construction
reads,
hours.
The code reads, as shown here, that the construction, demolition, alteration, or repair of any building, structure, excavation of streets and highways in areas zoned for residential use or in zones which abut or is adjacent to a single-family home shall be prohibited before the hour of 7 a.m. or after 7 p.m. Monday through Friday, nor shall work be performed on any Saturday or Sunday or nationally recognized holiday before the hour of 9 a.m. and after the hour of 5 p.m.
Okay. Let me hear from the code officer.
Officer Murillo, City of Miami Code Compliance. On November 17, I opened a violation based on a resident complaint on the address 12640 Northeast 12th Ave. This violation is irreparable and irreversible in nature on working on construction site extended hours on the weekends before 9 a.m. and after 5 p.m. on the residential zone. Notice to appear was posted on November 18, 2022. And I'm sorry, on November 19, 2022 for today's hearing.
All right. What's the time on that telephone?
That's 8:40 a.m.
What day of the week?
That's on Saturday, November 12th.
So that violates the code?
Yes, sir.
Do you have another picture?
There's another one. Yes, it's on 5:06 p.m. Same day, November 12th on Saturday.
What time again?
5:06 p.m.
Okay. Are there any workers on the site?
Yes, sir. If you could see one, I don't know if we could zoom it in. There's a worker on the top.
All right.
Sir Magistrate, if I may.
1 second before let him finish, and then I'll go back to you.
Okay.
There's also a video that was uploaded.
Same times?
Yes, sir.
Okay. And you cited the property owner by what method?
Excuse me?
How did you cite the did you post, did you hand deliver, did you
Yes, so I sent the I posted right on November 19. We failed it because of the nature of the violation. We failed it next day. I posted, and we also mailed it on November 22nd.
To the owner?
Yes, sir.
Okay. Are the owners local?
Yes, sir. Yeah.
Okay. All right. Let me hear. I see Louis Carbonell also, and Clarissa Burke. Mr. Carbonell, you're with the general contractor?
That's correct, Your Majesty.
Okay.
Please raise your right hand.
Go ahead.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Yes, I do.
Okay, Mr. Carbonell, we've heard evidence that there was construction going on outside of the hours that are permitted before 9 a.m. and after 5 p.m. at the site, and we saw evidence of some workers out there. Why do you contest the violation?
So if I may allow me to introduce myself, my name's Louis Carbonell. I'm the project executive for MB2A Group, which is the general contractor doing the construction on the property. The reason that we're contesting the violation is due to the fact that the workers are not physically working. They were congregating at the site, getting ready to enter into the site. It's a very large site. If you see from the pictures, they are not working in the morning time. And after the 5 p.m. time, what we're doing is that we're taking all the workers down, we're securing all the materials and ensuring that we have a safe site to ensure that no debris is flying away or anything. Everybody's being dismissed, but there's no physical work going on the site.
At what stage in construction is the project?
We're currently erecting the shell, the structural part of the project.
So on the day in question, those employees that were seen on the pictures, what was their trade? What were they doing?
So they're iron workers and carpenters. In the early morning picture, they're simply arriving to the site, getting ready to prepare. If you see, that's about less than 15 minutes prior to their commencing time. So they're just arriving to the site. They are logging in to ensure that they put the time that they've arrived so they can get paid, and getting their tools ready to go up to the working deck.
All right. Ms. Burke, do you have anything to add?
No, I agree with everything that Mr. Carbonell just said. I do also want to point out that in Section 535, the section was construed not to prohibit the construction work, but to simply regulate the noise production out of any construction site. So just to further elaborate on what Mr. Carbonell just stated, the workers were not engaged in any work. They were simply securing all of the work that had taken place prior to 5 o'clock, and they were securing all the materials on the deck to make sure that everything was safe, and as they were leaving the site.
All right, Officer Murillo, I'm troubled by the testimony of, not troubled, but mindful of the testimony of Mr. Carbonell. Just because you have employees there doesn't mean they're working. Is your video showing? Does your video show any type of work activity?
Yes, Your Honor. Give me 1 second. Let me pull up the video.
I have it here, I guess, but it's I'm not sure that it was play. It wouldn't play. Hang on. Do you have it on your screen, Gennaro, where you can share?
Yes, give me 1 second. That's one video.
What's the video? I don't know that he saw it.
1 second. That was a short video right there.
Is there a timestamp on that one?
The timestamp was on the pictures.
But not on the videos?
No.
So, respectfully, we can argue that the video could have been taken throughout the day during the work hours that are permitted.
I understand the rules of evidence, so I'm mindful of that.
Thank you.
If I may, Officer Perez of the City of Miami, I actually went to the complainant's house when this evidence was submitted, and those pictures of the timestamps were from specifically these videos. However, you cannot show them during the video. That's why I took the pictures separately. However, those timestamps depict the hours that it was taken, and again, it was before and after the restricted times. So there's also sound to the videos. I'm not sure why I wasn't playing. But it's clear and audible that construction was going on between those hours. As I mentioned, I was the one that responded to the complaint and received the initial videos. However, I delegated the case to Officer Murillo.
All right, Officer Perez, what kind of work activities were you hearing? Like hammering, moving stuff? I mean, what was the work?
Definitely a lot of hammering. It appeared that as if they were hammering stuff in. Definitely a lot of shuffling around and moving stuff. And I'm not sure, again, why the audio wasn't playing, but it appeared to be more than just personal hammers, it also included to possibly be maybe those industrial type of hammering down, because the sound was very loud in nature and could be heard from across the street.
This was before 9 a.m. and after 5 p.m.
That is correct.
I'm sorry,
yes.
about after 5 p.m.
That is correct, yes.
Officer, may you please clarify whether it was before or after?
Both. There's two videos. The video was taken before 7 a.m. and the other video was taken after 5 p.m. as indicated in the timestamps provided earlier.
Did you say before 7 a.m. or before 9 a.m.?
9 a.m. 9 a.m.
Sorry, 9 a.m. Yes.
Okay.
So if I may,
Mr. Carbonell, you're free to ask the code officer any question you'd like. You're free to cross-examine him in any way.
Officer, if I may, if we correlate the videos with the pictures for the morning time are showing workers that are arriving in their vehicles and moving into the site, not physically on top of the deck. And the ones on the afternoon or after the 5 o'clock, you can't even really see the workers doing their work or trying to understand what kind of activity they're conducting, as it's a very short video. But it seems that they're securing materials up on top of the deck. And we've asked clarification as to what constitutes the working hour once you're removing everybody and you're clearing and preparing your site to be safe for everybody to demobilize in the evening time.
While I understand that that's the objective to secure the site, however, the noise appears to be an issue, right? So at that point in time, that noise, the threshold being after 5 p.m. is now becoming a nuisance to the neighborhood. So while I understand that you're wrapping up the site, or the manager is trying to wrap up the site, they should do so and accordingly time so that by 5 p.m. there will be no noise, right? So if they need to stop 30 minutes earlier so that at 5 p.m. they can successfully be done with the project, then that's the matter that should be taken at hand, right? So as I mentioned, while yes, it appears that maybe they were trying to wrap up and maybe they were hammering stuff to secure stuff, that is still considered the work and the nuisance that caused the noise complaint.
If I may just add one last thing, the carpenters that we had on site right on that particular day were securing tables that are flown so we can pour the concrete and make the slabs. If they do not secure them in place, they're subject to being shifted or falling off of the deck, which, no one here wants.
Yeah, absolutely. That's not the issue. Well, obviously they have to be secured, but the question is, are you doing it prior to 5 p.m. or are you doing it after 5 p.m.? That's the issue.
Special Magistrate, I would ask that you recognize the building official. He's been working quite closely with the contractors, the property owner on this project. It is a pretty massive project. The city is sensitive to the fact that it does sit right smack in the middle of a residential area. So we were quite aware and conscious that, it could bring about some challenges. But specifically with a project of this magnitude. But there have been several early starts granted by the building official. As I stated, he is working quite closely. So if you would recognize him, and maybe, I'm not sure what his feedback might be, but I'm sure it's relevant to the issue.
Yeah, I will recognize him. I'm sensitive to what the general contractor is telling me, and given the very, very short amount of time before and after, I'm inclined to at least give him a break this time. I've never seen a case involving working extended hours, and it's by the way, it falls strictly within the jurisdiction of the building official. So I will defer to the building official as to whether or not what was happening there shortly before 9 a.m. and shortly after 5 p.m., whether he believes that it is in violation of the section that was quoted, 535D.
Yes. Hi, good morning. Good morning, Ms. Burke. Good morning again, Special Magistrate. What I wanted to add, I just want Ms. Burke to be aware, the times on Saturdays are set And during the week, we already established basically an early request and process that they have been the contractor has been following. But on Saturdays, it is you're surrounded by residential properties. Is there a way they can when the guys get started, make sure that after 9, that's when people are entering the site, and sometime even 30 minutes before, 45 minutes before 5, if they can start wrapping up the work site, so that way there's no indication that work is being done or people are on site. We just want to make sure we're sticking to that, so there's no issue with residents and with complaints to avoid the situation. Is there any way we can work on that, Ms. Berg?
Absolutely. We've put some procedures in place. On Saturdays, the gate is not open until about 8:45 a.m. to allow the workers to come onto the site to sign in and start going to the areas in which they will be working for that day. And that typically takes over 15 minutes for them to all get into the site. A lot of them are eating breakfast before they start. So those are some of the things that we've put in place for the morning time. Now in the afternoon, by about 4:15, 4 o'clock, our site supervisor, our superintendent, is in communication with all of the site superintendents that are there, and they start alerting the workers that they have to stop. We reiterate the working hours in all of our weekly subcontractor meetings. We've made commitments with our subcontractors. All the trades are aware of the working hours and the things that we have put in place. There are certain things, if they've started a particular activity and it's close to 5 o'clock, we have to abide by safety, and we have to ensure that the site is left safely. So some of those things are inevitable, but we have put some of those things in place, those measures in place, to make sure that they are leaving by 5 o'clock.
And is there a way that the gate, I guess, could be open at 9? They can line up in front of the gate, and if you want to do your sign in outside, so technically, people set foot exactly at 9 o'clock, and the gates are shut by 5. So that way there's no indication that technically people are working outside those times. Is there any way we can do that with the gates? I know it's going to be a little tough with your schedule, but is there?
We can definitely do that.
Okay.
Open the gate at 9 o'clock. There are times that, yes, we'll definitely open it at 9 o'clock.
Mr. Building Official, do you have the authority to extend the times within your discretion?
No, it's part of the ordinance. It's set, and we establish only during the weekdays for basically an early start request, and we go ahead and review that to approve it. But on Saturdays, it's kind of set, and I don't know if the manager has any authority on that, but it's really in the ordinance, so we're trying to follow the ordinance.
Yeah. In some cities, the building official has the authority to extend hours if necessary for good cause. In Bay Harbor, for example, you cannot work on Saturdays, period, unless the city manager specifically authorizes you for good cause. So I think the fact that the city allows Saturday work, requiring a 9 o'clock opening of the gates and at 5 o'clock closing of the gates, it sounds reasonable to me, unless a particular person needs to go in for some unusual reason to maybe turn on the power or something. Yes, Mr. Carbonell.
Your Majesty and Mr. Dean, if I may add, and we are more than willing to cooperate. I have personally walked and introduced myself to every homeowner in the surrounding area, giving them my personal contact information that they can reach me at any time. We are more than willing to work with everybody, but I believe that we need to be a little bit more considerate in terms of the gate opening. I think we could certainly improve in trying to get the workers out there before 5 o'clock, or start ensuring that the noise level is down, which is something that we're constantly working on, being mindful that we're working in a residential neighborhood. But I have, right now, I'm not even at my peak. At my peak, I'm going to have about 200, 300 men working in here. If you are to start working at 9 o'clock, that means that I'm going to have like about a half an hour or sometimes more, where I'm going to have a congregation of 100 plus men lingering outside the property. And what I'm trying to do is to allow them inside so they won't be as loud communicating with each other. Obviously, they're not going to sit there in their car. They're going to be in the surrounding neighborhood. I'm trying to get them into the site, let them get their tools and everything ready so they can start going up. As you could see, the problem wasn't as much as the morning time. It was what the neighbors were considering working additionally after hours, which again was to secure the site. But understanding that this is becoming a problem both for the city and for our site, our clients, and both our company, we're willing to accommodate in dismantling operations earlier to try to comply with that and try to have everybody outside the site. But I would respectfully request that we are not mandated to leave the gates closed in the morning. Otherwise, I would have a very large congregation of workers outside of the property lingering around. I think it would be safer and better for the community if they're inside. And if I may add, we're talking about a single homeowner that has made it a point to complain about this over and over again, constantly looking for something. I mean, this particular homeowner wakes up in the morning, has her coffee, and it's waiting outside the gate, trying to catch, the workers trying to do anything so she can complain about it. I mean, she's even sending her husband around the neighborhood to try to capture somebody else, and anything that it's work related, whether it's the city or somebody else, they're blaming it on us because we're doing the largest construction on the
Take her out for a cup of coffee around the corner and, be friendly. And look, this is a building issue. I don't understand, the sequence and how many at any one time, and whether it can be done during the week or can it be done on Saturdays. I'm not inclined to cite you because, number one, first time it's been before me. Number two, I think we're talking minutes, and I didn't hear, noise. I saw people moving, but I didn't hear noise. And even though that may be technically a violation, if they're there, I'm not comfortable citing you, but I do urge you to work with the building official, and, if he feels that inside is better or outside is better, construction sites will change depending upon the work that is being done. So I would ask you to see if you can get policies and procedures in place, including letting your workers know to keep their noise down. I've got a neighbor 2 blocks away, doing a massive construction, and I can sit outside and hear them clearly yelling at each other, and and telling jokes and disturbing people. It's noise carries. So let's be mindful of not just this neighbor, which may be an aberration, but other neighbors that may complain in the future if the noise gets louder. So, Mr. Building Official, I'm going to ask you respectfully to work with a contractor to devise a what do they call it with the Florida Department of Transportation, an MOT or MOD or something like that.
MOT.
Do some kind of an MOT or rules governing when and how employees, workers, laborers get there, and what they do before 9 o'clock or after 5 o'clock.
Okay.
Will that work?
We'll do.
Okay.
Magistrate, if I may, I just want to add, and just, echo his sentiments with respect to the issue. Please just bear in mind that, we have received a number of complaints, and we will likely continue to receive them. So whatever it is that you can do, obviously, because we took this case today before the magistrate, it does set a precedence for the neighbors in the community. So the expectation is going to be that we continue to proceed in this manner. So I really urge you and strongly encourage you to find some solutions as it relates to any noise before that time on Saturday.
All right. So number one, I've asked the contractor and the building official to work on measures to not only comply with the letter and spirit of the code, but also to minimize noise to the fullest extent possible. I'd like there to be some kind of a written understanding between the city and the contractor as to what is and what is not appropriate. Number two, I'm letting the contractor and the owner know that because this is a first time, I'm inclined to, and because of the short period of time involved, and because I couldn't really hear on the video, real noise. I'm going to give them a break. I'm going to find them not guilty. But the next time they come, especially if it's, instead of being 5:02 or 5:03, if it's 6 o'clock, or instead of being 9 o'clock, it's 8 o'clock, then the penalties will be very severe.
Understood.
So your magistrate.
Thank you.
Okay. All right.
Thank you.
And I appreciate the neighbors' concerns, and I know that anytime there's construction, there's going to be noise, there's going to be dirt and debris, there are going to be construction trucks, and there are going to be people in the neighborhood that maybe don't belong there. And so, yeah, I understand the neighbors' concerns, but on the other hand, the owner has the right to develop their property within the code. And that may cause some inconvenience to the neighbors, but it's something that we in an urban community like North Miami have to be mindful of. Anyway, that's it.
Thank you.
Next case.
So the case was dismissed, right? For the record, was that
case? Unless you can find another way to.
Were you adjudicating with no fine? Is there?
No, what I really would like to do, and maybe we haven't done this before, is to get like a status report in 60 to 90 days and see where we are. And of course, if there's another violation, you bring it back to me immediately. But I'm not going to adjudicate on this case.
Okay, I would probably say, magistrate, because we brought the item as a one-time fine type, in nature. I think that it's well within your purview to either dismiss the case, and if it happens again, we just bring it again, or you adjudicate the matter with no fine.
Well, there's a technical violation of the code, obviously, because of the times that I saw on the record. But because it is a first offense, and because the violation, I would consider the violation in this particular case to be de minimis, I'm going to find that there is no fine.
Okay. With an adjudication?
With an adjudication and no fine.
Okay. Clerk, did you get that?
No.
So he's adjudicating, it's a one-time case, so it's irreparable and irreversible. He's adjudicating guilty, but there is no penalty. So that'll basically close this case.
Okay. Now, not even a court cost?
I think a court cost would be appropriate.
No problem.
$100.
Noted.
Thank you.
Okay.
Your magistrate.
Yes, sir. We're done. If you have any questions, sir, direct them to the building official or code.
Understood.
Basically, it's a technical violation of the code, but because of the circumstances that I found, I'm not going to assess any fines.
Understood.
Okay?
Thank you, Your Magistrate.
Besides the court cost, there's
Besides the
no
court
fine,
cost.
but there is a court cost.
Yes.
All
Understood.
right. Have a good day.
Thank you.
That's a good solution, Crystal. I appreciate it.
You're welcome.
Appreciate it. I was gonna say $1, but it would have been criticized for certainly by the neighbor next door.
Yeah, yeah.
I'm going to proceed with item number 33. Roy Jacobs, sorry if I'm pronouncing your name wrong. And case number is CEMIS 2022-00051. And the officer is Christopher Colson.
I have a Dion here on behalf of this property. Dion, if you want to join the meeting, please. Dion, if you can enable your audio and video.
All right, swear them in.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
I do.
Good morning or good afternoon. This is a new case about canopies. CEMIS 2022-00051. The case was originally opened on 3/9/2022 for carport canopies that were put up. They were properly served and noted. The code says they are allowed one canopy per home with a permit. I had previously spoke with the homeowner on 11/18. We had a great conversation about different things, but about mostly the case. And he has an understanding of what it entails. He has agreed to remove one of them. My conversation with him on the 12th, he hasn't removed it yet. That's when he agreed to remove one of them on 12th of December. But violation still remains at the time of inspection, of final inspection. So as of right now, he's still in compliance.
All right, is there one or are there two canopies currently?
There are two canopies currently.
Okay. He can have one with a permit?
With a permit.
Okay. And this is within the land development regulations or is this code?
It's in the code. It's within our
development regulations.
And development, yes.
Okay. All right. Let me hear from the property owner. Sir, ma'am, please tell us who you are and where you live and what is your relationship to the property.
I'm
Can't hear you.
Can you hear me now?
Can you hear me now? We can hear you. We can hear you. It's just muffled. So I think if whatever device you're using, maybe you may just want to lift it up. It sounds like.
Can you hear me better?
Yes.
Okay. My name is Dion Akis. I reside at 13745.
It's kind of happening again. Maybe you have your hand covering your speaker.
I'm not covering it in any way, but I'll try to speak as loud as I can. Can everyone hear me?
Maybe consider turning it sideways. Are you using a phone?
No, I'm on
a tablet.
Laptop. Excuse me, laptop.
Right, your audio is definitely going in and out. It's kind of like a muffling in and out, kind of almost like you have something over the speaker.
Nothing, absolutely nothing on this. Let me see, microphone.
That's better.
We don't
Can't
hear
hear you at all. Speaker, hold on.
We can hear you now.
Okay, you can?
Yes.
Okay, I'm not even touching anything right now. I'm afraid of Xing out.
It's perfect.
Okay.
Tell me again who you are. Where do you live?
My name is Dion Akis. I reside at 13745 Northeast 10th Avenue, and I am one of the property owners.
Okay. Do you understand the nature of the violation?
Not really, sir.
Okay, we lost you again. Let me take advantage of this opportunity to explain to you what the violations are. Number one, you can only have one canopy, not two, only one. The other one has to be removed. And also, as to the one that you keep, you have to have a permit for it. Am I stating it right, Mr. Colson?
Yes, you are.
Okay, can you hear that?
Yes.
Can you hear me?
Yes.
Okay, I heard what you said.
You're going in and out. Sometimes we hear you, sometimes we don't.
What am I doing? I don't Can you hear me? Can anyone hear me?
Yes.
You guys just have a cell phone, maybe? You just try dialing in from your cell phone as an alternative for your audio. Just try dialing in from a cell phone. We don't hear anything you're saying, so just give it a moment until he dials in.
Okay, I just popped the laptop on something. Can you hear me better?
Yes, we can hear you now.
Okay. All right. So based on what you said,
Yeah, maybe I think when you lean in is where the issue is.
How about now?
Better.
No, you guys just need to dial in. Just dial in so that we can just have a steady connection.
I'm not sure. Specific number to dial that I can dial you?
I don't hear you, but I'm guessing you're asking for a number?
Yes, I'm asking for a number.
Clerk, do you have the dial-in number by chance? All right, this is what we're going to do. I'm going to table this for a moment. The clerk is going to send you something in the chat with the dial-in number, and then we'll come back to your case so that you guys can dial in, okay?
All right.
Thank you. Clerk,
All right.
please send them the dial-in information, and you guys dial in, and we'll come back to you.
Where's Jose?
I'm ready. Next case.
Item number 34 and 35, Scott E. Larson, case number CE BPR 2022-00556. Item number 34 and item number 35, case number CE BPR 2022-00703. And the officer is Jose Perez.
Is this for Scott Hayden?
No, I believe it's Christian that's going to be testifying on behalf
Christian
of the property
Desada?
owner.
Okay.
Yeah.
All right, Christian, if you can enable your audio and video, please. Thank you.
Hello, Christian.
Good afternoon.
Good afternoon. Please raise your right hand. You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
Please, sir, would you state your full name, address, and your relationship to the property?
Yes, my name is Christian Desada. The property in question is 2080 South Hibiscus Drive. And I am speaking for Mr. Larson today because he is unavailable. He's out of the country.
What position do you hold with the building owner?
So I am the subcontractor who built the pergola on the roof. And I am the party that's currently working with the city to obtain the permits required. There were some misunderstandings, so we're working diligently.
Okay, Madam City Attorney, we don't have the owner, we don't have the general contractor, we don't have an attorney, we have a subcontractor who's here testifying as to the circumstances of this particular case. Is he qualified to testify? Has he signed an affidavit? Does he have a power of attorney? All of those things.
They submitted a power of attorney to our office.
Okay, there you go. Good morning, Your Honor. Assistant City Attorney Veronique Magbush. I was just going to ask if he has a power of attorney. As long as he has the property owner submitted one for him saying that he can testify, then he's fine. He's qualified.
Okay, sir, to shortcut the, not that I want to give you, not an opportunity to explain, but I'm familiar with the file. I've reviewed it in detail. I know what the code provides. I've looked at the plans. Okay, so the issue here, from what I understand, and correct me if I'm wrong, you have either a canopy or an addition that apparently exceeds the height limits of 35 feet. And is that my understanding? Is that what this case is about? Can't hear you. You're muted.
Apologize.
Okay.
Somewhat. Officer, do you want to chime in as to what exactly the violation is?
All right. I was just giving you an opportunity to, tell me if you can test the violation or not.
Well, I believe the violation is work done without a permit and in that case, no, I do not contest that at all.
Well, that's not before me.
Okay. The issue.
Well, there is the next violation, the one that we're going to hear next, is working without a permit.
Okay.
But the one before us right now is about exceeding the height limits.
Okay. So exceeding the height limit, allow me for a moment. I do have a hearing. It's before the Board of Adjustment. It's going to be on the 18th of January.
No, I'm sorry, Magistrate. We don't have a case, Jose. We don't have a case regarding height limits. That is an issue on this property, Magistrate. But what we brought before you today is two violations. One is both are reference construction without permits. One is in reference to the canopy, the pergola on top of the roof. The other is for the installation of a shower.
Okay,
right.
But you have a lot of information, and what you're speaking to is valid on this property. But that's something that's being dealt with through the appeal board and the zoning department.
Okay. So the narrow issue, is you want to see the permits on the newly built canopy on the roof. That's what the city's asking for.
Correct.
All right. So do you have a permit or not?
So I have a permit in process. The permit was denied because of the issue you just brought up, which is the height issue. So I have been in process for some time getting these permits organized so that we can correct this entire situation, working diligent on it.
You're looking for a variance?
I am looking for a variance because of a very unusual condition, yes.
Well, they've been denied, and they're looking to appeal before the city council.
In fact, we've been denied because of a essentially, long story short, is the pergola is built at the same height as the structure, as the building, okay, which it is necessitated to its construction. The problem is that for some reason, the building was built in excess. The building was built accidentally 1.5 feet too tall. So now we have to go through the process of addressing the height of the building in order to be able to obtain this permit, because there's no way to make both things work together.
Okay. This may or may not be relevant, but I need to have it cleared in my mind.
Of course.
Does the city, even though the variance was denied, does the city have the ability?
Well, the variance wasn't denied. The variance wasn't denied. The permit was denied. The permit was denied because I need to obtain this variance or this special dispensation for the height.
And is that before the city commission?
On the 18th of January.
Okay, and what is your request?
My request is to be able to clarify the fact that the structure itself is in violation. If we can clarify that and be able to somehow legalize that, get a variance for that, I'll be able to obtain the permit properly for this pergola.
Okay, Mr. Perez, he doesn't have the permit.
That is correct.
What does he have a permit for the structure?
So the home was recently built. It's a newly built property, right? The property was property permitted. However, after the fact, the pergola was added to the property once the new property owner purchased the property. So I think in order to expedite this case, the property owner is not contesting the violation. They're trying to obtain the permit. The city is just seeking an adjudication at this time, and we're willing to give them the time needed so they could get the variance approved or not approved, whichever happens, and we could give them the time, but we just seek the adjudication for both cases.
Okay, I understand, and I appreciate your conciseness. So a building permit was issued for the house, and then the owner added this extra space on the roof?
No, what happened was, and again, there's a lot of history to this property, but just to sum it up, we're talking about two separate property owners. So the property was sold recently to the current owner. So the changes that, the height, the issue around the height was with the initial owner. This is a new owner who has since added to the structure additional structures without permits.
Without a permit. Okay, so I'm going to rule just on that narrow issue that the addition was made without a permit based on the testimony that I've heard, which is unrebutted. The photographs and the evidence depict that the violations still exist. Proper notice having been given, I find in favor of the city, enter an adjudication and set a compliance date of 90 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Okay.
Okay, on that issue. Now we go on to the next case. Has it been announced yet? Clerk?
Yeah, I believe she called it announced.
Okay, this seems to be relatively easy. Apparently there was a shower that didn't belong there because it's not one of those appurtenances that are allowed above 35 feet. So it needs to be removed. Has it been removed yet, Officer Perez?
No, at this time it still remains there. So again, we're just seeking adjudication and allowing them time to rectify the violation.
Okay, that should be very easy, right? There's the shower, circled in red. Mr. Zasada, is that something you can do pretty quickly?
I should think so. If you could offer me the same 90 days, we should be able to solve that problem without too much trouble.
Okay. No way to do it in 60?
I imagine we could do it in 60. I just figured if you give me 90 days, there's certainly no issue whatsoever.
All right. I'll be lenient this time because you've been so nice about the various issues that we've considered. I will do that based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 90 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. And of course, I'm mindful that we are in that part of the year, the season where a lot of people go away on vacation and it's very hard to get things done at City Hall. So, the next 15 days are basically wasted. anyway. So let's move on to the next case.
Thank you so much.
Yeah.
Clerk? All right, so I guess I'm gonna okay, there she is.
I was looking for the information for Miss Diane.
We have one more person here, Scott Hayden, in the queue. Mr. Scott Hayden, are you here? What case are you here on behalf of?
Good morning. I'm here on case CEFOB 20.
What's the address?
It's 13343 Northwest 7th Avenue on behalf of the landlord, Bimini Properties. I don't see my video on the screen.
Shada, is that case is on the agenda?
It is.
What number?
For Bimini,
I'm sorry, your audio is muffled.
it is. Let me click on here. That's for 13343. It is case 12 and 13.
Okay, thank you.
All right, I'm going to call item number 12 and 13, which is Bimini Properties, Inc. Case number is CEFOB 2022-00101. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $500 plus $100 cost assessment. And as for item number 13, case number CEDC 2022-00247. And this case was also previously found guilty with an abatement date of December 2nd, 2022. Fine set at $500 plus $100 cost assessment.
Okay, Judge. Good morning.
Good morning. Are you the lawyer or the property owner?
Yes, I'm counsel for the landlord, Bimini Properties.
Okay.
What's going on here is we have a tenant running a vegan restaurant out of this property, and he's been to City Hall many, many times and seeking this BTR and the certificate of use, and he's been declined. His applications and his requests have been denied because he's been told that he doesn't have a fog. And
he doesn't have what?
A fog, a fat, oil, and grease control device.
Okay.
And I would say that he doesn't qualify as a fog generator under the code, under the county code. It would be, the definition of a fog generator means a fog generator shall mean any non-residential facility, including a restaurant, who I'm skipping ahead, who can introduce food waste or fog into a building sanitary drains or building sewer system. But he doesn't do that because he doesn't use fat, oil, and grease. It's a vegan restaurant, and he avoids using oil and grease, and therefore I don't believe he needs a fog control device. He's tried to explain this when he goes to City Hall, and I don't know what he's been told exactly by the city representatives, but it's a situation where they're telling him he needs something which I don't believe he needs, which he doesn't believe he needs, because he doesn't produce these the fat, oil, and grease, but that's the holdup as to why he's been unable to obtain the BTR. My suggestion would be, if the city wants to have someone come out to the restaurant to inspect it and see whether or not it's necessary to have a fog control device, or whether or not he qualifies as a fog generator in order to need one, I think that would be fine. It's a situation where if he's going to go out and spend the thousands of dollars to obtain a fog device, he needs to know whether or not it's actually necessary or like,
All right. I understand, and I am no expert on any of the things that you just talked about. I do know about restaurants and grease traps and what's necessary for DERM and all of those kind of things. But considering that, as you say, it's from what I saw in the pictures, this person is a herbalist, or as you say, a vegan. So he doesn't cook.
Correct.
He doesn't cook. So based on that, which code officer is going to explain this to me?
Shannon
Ms. Sanders?
Yeah, Shannon Sanders, City of North Miami Code Compliance Officer. Case property address already given, 13343 Northwest 7th Avenue. I've had this conversation with the property owner as well as the business owner of all the things that the attorney is stating. I explained to him that wouldn't be me as a code officer in or the Community Planning and Development Department. I pointed him into the direction, as well as Community Planning Department pointed him into the direction of Durham. He would have to make that appointment with Durham, and they would be the ones to let him know or give him documentation stating that that's not needed in order for the city to move forward with issuing him their certificate of use and business tax receipts. We've had this conversation since my initial opening of the violation almost a year ago. We're a month short of a year that we've been having this same conversation about visiting Durham and getting that proper approval or non-approval or whatever they provide, stating he doesn't need that grease trap. But as of my last inspection on
Mr. Hayden, have you been hired recently, and are you aware of prior communications with Ms. Sanders?
I've never personally spoken with Mr. Sanders, Judge. I believe that she's maybe spoken with someone else on behalf of the property. But if what it takes is going to the county and calling Durham and having a Durham officer come out to the restaurant to say whether or not a fog is required or not, we can do that. And I would just ask for a 30 days in order to set that up and have someone from the county come out and let us know what's. Well,
are you aware that I have previously found your client guilty, and based on the fine that I imposed, it was probably a hearing where your client did not attend, because I tend to be a little bit harsher on folks that just don't show up to explain what you just explained to me.
I wasn't aware of that, Your Honor. No, and I apologize.
But there was I found him guilty on September 13th, or thereabouts, because I saw my order, and it was for the failure to have a business tax receipt and a certificate of use.
Which is what we're here on today, and I wasn't aware of that hearing, Your Honor. I did come into this just a couple days ago.
Yeah, well, that's the history, is that had you come before me back in September, I probably would have given you time to go to Durham and get whatever decision you needed. Mm-hmm. I don't know if the building official weighs in on these decisions, but I would have spoken with the building official as well. What is the recommendation of the city, Ms. Patterson?
I'm sorry, I missed your question.
Yeah, based on the circumstances that the council was not here when the finding was made, when I entered my order in September. Right. And I typically increase the fine to $500 when the owner doesn't show up, which leads me to believe that the owner didn't show up to that hearing. Maybe he had noticed, maybe not, maybe he just ignored us. Right. But it was December 2nd. Okay, so what is the administration's recommendation?
I would, the one point that I just wanted to make note of is that generally, best practice is to obtain your CU before you rent the space, as to ensure that, the space that you're renting, number one, the use is permitted, and number two, that you have, all that's required as per zoning. So, based on the circumstances and the fact that that did not happen, and this is an after the fact circumstance, it's been a year to date, as the officer noted, just about. Magistrate, I would leave it up to you. The city's okay with running the fine at this time.
With what?
I would just say
okay with moving the fine forward at this time.
Okay, mind you that the original fine was issued in January of 2022, and We don't have a business tax receipt. We don't have a certificate of use. There was certainly plenty of time to go to Durham or the county and figure out what was needed in order to operate this business. I appreciate what you're telling me, that this business doesn't need it, but here we are a year later, and we're still fighting.
I would say that I'm here first and foremost on behalf of the landlord. We're talking about a CU. That the tenant or the business owner is required to obtain, and he has attempted many times to go to the city. I think it's just a situation where he was knocking on the wrong door and wasn't getting the right instruction or advice on what he needed to do. And with regards to not appearing at the last hearing, there's I'm sure it wasn't intentional on behalf of the owner of the property, my client, not attending. He probably didn't receive notice. I'm not sure exactly.
Well, I just want to make the magistrate aware that the business is operating. It's been operating. It's been open since day one. They continue to operate.
That's not disputed. The problem is the fat oil.
Whether it's disputed or not, I think that what we're, whether the notice was delivered, an attorney has been since retained. This is a hearing on whether or not compliance has been met on the order that was issued back in September. And the fact of the matter is that the tenant came to the city. He was instructed on how to move forward. You read the county ordinance yourself. It's not a city code, it's a county ordinance. So I think that, really, the onus is on the tenant and the property owner to ensure compliance. It had been just about a year. The city is prepared to move forward and request that the magistrate ratify the fine. If in the event that you guys come into compliance at a later time, the city is always open to, look at that from a look at the liens or the fines that have been accrued, and mitigation is always an option.
I would just say again, I think it's a matter of knocking on the wrong door and showing up to the city when he should have been knocking on the county's door.
Yeah, well,
I agree.
That's unfortunate, but he's your tenant, and Ms. Patterson said it correctly. There will be a time and a place where the property owner will A, come into compliance, or B, terminate the tenancy and ask the tenant to vacate, because you're going to be accruing fines if this tenant keeps on doing business without these licenses that he needs. So, either way, you have options. You can certainly recover any penalties or fines from your tenant because he didn't comply, he didn't do his due diligence, whatever it was. But, these orders that I enter have to mean something. They can't just be ignored because somebody's knocking on somebody's door, or they have a different understanding of what the code says or where to go, or, you could have helped them, or another lawyer could have helped them, or coming to the city, as I believe one of the code officers that testified said that she's been explaining this to your tenant over the last year, and we're still back. An application hasn't been even made with Durham, as far as I'm concerned, and here we are a year later. So I don't want to talk anymore. This is one of the problems of being a landlord. You get up, you find yourself with bad tenants from hell. I've had them. I know what they're like. So based on the testimony of the city's code compliance officer, the photographs and the evidence presented that the property has been out of compliance since the abatement date, I find in favor of the city, and I hereby ratify the fines accrued to date in the amount of $500 and assess costs in favor of the city. The fine shall continue to run on a daily basis until there is compliance.
What's the daily fine, Judge?
500.
500 a day?
Yes.
And it'll continue to run until
there is compliance. Okay. Now, once there is compliance, whether it's next month or next year, you have the ability to go back to the city and we call it mitigate the fines based on equitable principles.
I understand.
So, that's the fine that I'm required to impose. And then you have another opportunity at some future date, but only after you come into compliance, to get the fines reduced. Okay?
Understood.
That's the only way I can explain it. We have two cases here, or just one?
Two. We have one for the certificate of use, and then the second for the business tax receipt, kind of going hand in hand.
Okay. Same ruling on the business tax receipt.
So it's $1,000 a day for the combined?
Yes. Two different violations. You can mitigate the fine by closing down the business, then you don't need a business tax receipt or a certificate of use, but they're going to have to shut down, at least until they get the permit. Okay, next case.
Thank you.
I believe we're waiting on Dion because there's no more attendees in the.
All right, so let's see if I forgot about that. Dion, are you guys ready? Do you have your audio? I don't see you signed in from audio from a phone, but we'll try it. Did you guys call in?
You're muted.
Go ahead.
I don't know. Can you?
In the chat, I sent you the information for the dial-in.
Well, I have my laptop up as well as the phone.
Right. No. So from the phone, you were just supposed to call the number she provided you like it's a regular phone call.
I didn't receive anything from anybody.
It's in the chat, ma'am. There's a chat feature on the Zoom link, on the Zoom call.
I wasn't aware.
Okay, or since you have both devices on, from the laptop, mute the laptop and do the audio from the phone.
Okay, mute the laptop. Okay.
And then on the phone, enable your audio. Unmute your audio.
Okay.
I've already muted you on the laptop. Just turn on your audio on the phone. But we don't hear you on the phone, so you need to press mute on the actual device. Press unmute yourself on the device.
Oh, I just realized they're probably on the city's live channel.
All right, hang the call up on the phone, and I'm going to give you the number, and you just dial the number. Give her the number, please, Peggy.
No problem. It is 649 558 8656. And then the webinar ID is 829 7462 8062. Can you hear us? The number? It's 646 558 8656. Participant ID 618511. Can you hear us?
We can't hear you. All right, so this magistrate, we're going to table your case for 30 days. If that's okay, magistrate.
Yeah, what number was that case?
I don't know, the clerk, I would recommend that we table the item for 30 days. I think that, I know I've spoken with the property owner personally. The purpose of the hearing today was for the magistrate to hear your case. I highly encourage that net 30-day window because of these audio issues. If you guys don't come into compliance, meaning removing one of those canopies and coming to obtain the permit for the other, that if you plan to, if you want to dispute the case and you come back in 30 days, that if you don't have your technical issues together, that you can come to the city. We have a computer here that you can use in next month. But I highly encourage you just to, work on getting the permit for the canopy and use that time, to do that. If not, you can come to the city and use our computer next time.
Yeah, considering that you already know what the issues are and how to go about resolving them. Come 30 days, if you haven't made significant progress to getting that canopy permitted, you're not going to be happy with my ruling. Okay? So you got an additional 30 days. I can't hear you. I
both down for the weekend. I'm going to dismiss both.
I can't hear a word you're saying.
Give me a call. I think I heard what you said. You said you're gonna take them both down before the weekend, but just give me a call and I'll come back out and I'll reinspect
I'm not in a secret. I'm gonna just take them down. I've been here 41 and a half years owning this house. That's been up for 12 and a half years. I've been a stellar citizen in North Miami with city manager, former Johnson, Mayor Smith Joseph. His wife worked on the modification for us.
Sir, I don't care about politics.
I'm just going to take it down. I'm going to take them down.
I don't care about
I understand. I'm going to take them down.
There's a violation, whether it happened 10 years ago or yesterday. There's a violation, and we have to enforce the code. Mr. Colson, please speak with them and let them know what they need to do to comply.
They're coming down tomorrow.
Okay, once you take them down, I'll come back. Give me a call or a text, and I'll come back.
I'll call. Just drive by and see.
And I'll see that.
You have my word. I've never went against my word. They're coming down.
Okay, we believe you. Okay, so that's how it's going to be resolved. It's coming down and will come before me. Very good. Excellent. All right, next.
The next case is?
Yeah, we don't have anyone else here physically, so all the other cases, magistrate, are just represented by the city. I don't suspect that there's a need to take a break unless you feel like you need a 5-minute. We could try to get through the rest of the agenda.
That's a good idea. I need to get a drink of water, so let's take 5 minutes.
Okay.
You still need the interpreters to remain connected?
No, you guys can be dismissed. Thank you.
Thank you. Happy holidays.
Likewise.
Recording stopped.
All right, guys, I'm back. Let's keep moving.
All right, sounds good.
Recording in progress.
All righty. Get the clerk on.
You're back.
All right, so I'll just take it from the top. I'm not sure. We'll move forward with item number 1, case number CEZCU 2022-00404, 1065 LLP. The code officer is Christopher Colson. The property address is 1065 Northeast 125th Street.
Good afternoon again. This case is a new case for certificate of use. My name is Officer Chris Colson of the City of North Miami Code Compliance. This violation was originally opened and proper notice was given. Our violation was opened on 4/15. That was mailed on 4/19/2022. Case was filed for magistrate on 5/13/22. All other proper notices were given. As of final reinspection of 12/8/2022, there still is no compliance. There's no certificate of use on file for this property.
This is a real estate office?
Yes, it's a real estate office it's a big office building with several businesses within the building. This is one of the businesses that are within the building.
Okay, are you citing the real estate company or the property owner?
I'm citing the real estate company, Cheryl Kaufman's Real Estate.
Okay, and who is 1065 LLP?
That's the whole building where the office sits inside.
Okay, so you're citing 1065 LLP, not Cheryl Kaufman.
No,
well, the violation runs with both, per our code magistrate, the violation runs with both the property owner and a violator is defined both property owner and tenant.
Okay, so the tenant's on the hook also.
Correct.
Yes.
All right. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation exists and that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Okay, clerk, are you back? Or should I keep clerking? All right. You're on mute.
Sorry. 1 second. Item number 2, 131 Sunrise Plaza LLC. This case was previous case number CFOB 2022-00124. This case was previously found guilty within a abatement date of September 2nd, 2022. Fine was set at $250 plus $100 cost assessment. And the officer is Shanna Sanders.
Shanna Sanders, City of North Miami Code Compliance Officer for case 13136 Northwest 7th Avenue. As already stated, it's already been previously adjudicated. As of my last reinspection, compliance has not been met. I am showing proper service was given. I hand delivered the notice to appear to the business owner on November 18th of 2022, whereas they stated they would be here. My last reinspection of the computer and the property was on December 2nd. No applications have been submitted to the city.
All right. I made a note when I went through the file that in the violation notice, you cited 11-9 as the section of the code. It should have been 11-19. So it doesn't make any difference, but just note for the record that the violation for business tax receipts are under 11-19, not 11-9. Okay?
Yeah, when we did the agenda review, that was brought up some months ago. So that's why this one came up long after. As you probably know, we usually do the CUs and BTRs together. We resent a notice with the correct code section. So yeah, that was previously noted and correct, was cited. It should have been taken out of the old case docket, so it wouldn't show anymore, but that has been put in on record and uploaded correctly.
Okay, so this was previously, the property was found, or the business was found guilty back in August of 22 by Magistrate Suarez Rivas. I see that it was tabled October 24th for some unknown reason. I don't know, but here we are, long after the compliance date. So I am going to ratify the fines based on the testimony of the city's code enforcement officer and the evidence presented that the property has been out of compliance since the abatement date of September 2nd, 2022. I fine in favor of the city and ratify the fines accrued to date in the amount of $250 a day, and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance.
Item number 3, 315 Northeast 122nd LLC. Case number CEPAR 2022-000003. Case was previously found guilty with an abatement date of December 2nd. Fine was set at $250 plus $100 cost assessment, and the officer is Shannon Sanders.
Shannon Sanders, City of North Miami Code Compliance Officer, property address 315 Northeast 122nd Street, here to present the case for non-compliance for a property that was painted outside of the scope of what the city usually allows. I am showing proper service was given. I posted a notice with the notice to appear on November 18th of 2022. As of my last reinspection on December 2nd, compliance has not been met. No applications have been submitted to the city for the color approval.
This was a matter that I heard, I believe, on October of 22, and fine was imposed, $250 a day plus costs. I'm showing a Christopher Powell as the manager and registered agent. I would suggest that you send a copy of my order to them as soon as it's entered. Based on the testimony of the city's code compliance officer, the photographs of the residents and other evidence presented showing that the property has been out of compliance since the abatement date of December 2nd. I hereby ratify the fines accrued to date in the amount of $250 and assess costs in favor of the city. The said fines shall continue to run on a daily basis until there is compliance.
Item number 4, AM and Associate Enterprises, PA. Case number CEFOB 2022-00244, and the officer is Gennaro Murillo.
Officer, go right ahead.
Good afternoon, Officer Murillo, City of Miami Code Compliance. On April 18, a violation was opened on the property address 1683 Northeast 123rd Street for heavily organic bag not renewing their business tax receipt after its expiration on September 30, 2021. On May 24, I conducted a reinspection. Application was made. On November 18, I handed notice to appear to Amelia Javier for today's hearing. And as I'm at final reinspection on December 2nd, 2022, there was no application made.
Okay, I have a note that the citation refers to code section 1129. The appropriate code section should be 1119. And just note that for the record. I will ratify the fines based on the testimony of the city's code compliance officer I have not ruled on this one before, right? This is
No.
a new case?
Yes, sir.
Oh, it's a new case. I thought it was a ratification. So, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Item number 5 through 7, Andrew K. Cucci and wife Perlin. Case number for item number 5 is CEBPR 2022000434. Item number 6, case number is CEBPR 2022000435. And item number 7, case number is CEBPR 2022000437. And the officer is Aaron Barber.
Good afternoon, Aaron Barber, City of North Miami Code Compliance. These 3 cases, these are new cases. The first case was for an air conditioner that was installed without permits. The initial inspection was March of 2022. The resident had been given an extension back in November. However, as of the final recheck date of this morning, 12:15, there is no compliance. Notice was mailed to the property owner, certified, and posted at the property.
All right, let's deal with number 5 first.
Okay, yes, this was case number 5, air conditioner installed without permits.
Yeah, I noticed that a 60-day extension was given by staff back in October.
Oh, yes, sir. Yes, sir. I misread that. Yes, yes.
Right.
October.
I looked up Section 532, and a violation of Section 532 calls for a $500 fine. I think that's what I found. Anyway, not that I'm bound by that, but I'm looking at that in determining what the appropriate fine would be for building without a permit. So, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists and that proper notice has been given, I find in favor of the city, enter an adjudication and set an abatement date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you. Item number 6. This is also for building without a permit. New case, same property, 13025 Northwest 16th Avenue. Violation opened in March of 2022, and as of this morning, there has been no compliance. Notice was mailed, certified, and posted.
And a 60-day extension by staff was granted on October 6.
Yes, sir. Yes, sir.
Okay, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you. Item number 7, same property, 13025 Northwest 16th. This is also for building without a permit. This is for windows and doors that were installed at the property without permits. Initial inspection, March 2022. The extension request from October was also given in this case, and as of this morning, there was no compliance. Notice was mailed, certified, and posted at the property.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented, depicting that the cited violation still exists and that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 60 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
You're welcome. How many more do we have?
I'm going to proceed with item number 10, Bank Enterprises LLC.
I'm sorry, what number?
10.
Okay.
Bank Enterprises LLC, case number CEFY 2022-00155. This case was previously found guilty with an abatement date of December 2nd. Fine set at $500 plus $100 cost assessment. And the officer is Aaron Barber.
Aaron Barber, City of North Miami Code Compliance, has noted this case has been previously adjudicated. Notice has been posted and mailed certified, and as of 12/14, I was out at the property yesterday, and they are still parking on the lawn, so there is still no compliance.
All right, and I found them guilty on October 20th and set a fine of $500 plus costs. So based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented, that the property has been out of compliance since the abatement date of December 2nd. I hereby find in favor of the city, ratify the fines accrued to date in the amount of $500 and assess costs in the amount of $100. The fine shall continue to run on a daily basis until there is compliance.
Thank you.
Item number 11, Barton and Gestier USA Inc. Case number CFOB 2022-00215, and the officer is Jose Flores.
Officer Perez with the City of North Miami. Today we're hearing the case in regards to the property at 12550 Biscayne Boulevard. This violation is in regards to the failure to obtain a business tax receipt for Surveillance Enterprises Corp. As of my final reinspection, unfortunately, they have not obtained their business tax receipt. The violation was originally created on April of 2022. The property owner was sent via certified mail the original notice with a reinspection date of May 23rd, 2023, which unfortunately compliance was not met. The notice was sent also to the registered agent of the property owner at 1200 and Teresa Avenue in Coral Gables. And the notice to appear was sent out on November 22nd, 2022. And the notice to appear was also posted on the property on November 22nd, 2022 for this case. At this point in time, the city is seeking an adjudication and a monetary fine until they obtain said business tax receipt.
Based on the testimony of the city's code compliance officer, the evidence presented showing that the property has been out of compliance. No, this is not a ratification. This is an adjudication, correct?
That is correct, yes.
Okay, I haven't ruled on this before. All right, based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 14, Causeway Square LLC. And the case number is CEFOB 2022-00227. And as well as item number 15, case number is CEZCU 2022-00394. The officer is Jose Flores.
All right. Would you like to hear both cases at the same time? It's for licensure.
No, let's do 14.
Okay, no problem. So Officer Perez of the City of North Miami, today we're hearing the case in regards to the property at 1865 Northeast 123rd Street. This case is for failure to obtain a business tax receipt. The total bank at the property, unfortunately, has not obtained the business tax receipt. They originally cited back in April of 2022 with a reinspection date of May 23rd, 2022. Unfortunately, as of the reinspection date, they had not obtained the business tax receipt. The notice was sent via certified mail, not only to the property, but also the registered agent. The then notice to appear was sent out via certified mail on November 22nd, 2022. And it was also posted at the property on November 22nd, 2022. At this point in time, the city is requesting an adjudication as well as a monetary fine.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented, depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city and enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
So for case number 15, Officer Perez of the City of North Miami considering hearing the case in regards to the property at 1865 Northeast 123rd Street. This case is for a certificate of usage and lack thereof of obtaining one for the Total Bank at 1865. At this point in time, the violation was opened in April 2022. They had a reinspection date of May 23rd, 2022, where they did not comply. The property was sent via certified mail to the registered agent, and it was also posted on the property. In regards to the notice to appear, it was also sent via certified mail on November 22nd and posted on the property on November 22nd.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice having been given, I find in favor of the city and enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Yes, sir.
Item number 17 and 18, we have Gerardo M. Rodriguez. Case number for item number 17 is CEFOD 2021-00061. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $250 plus $100 cost assessment. And as for item number 18, case number CEDCU 2021-00200. This case was also previously found guilty with an abatement date of December 2nd, 2022. The fine was set at $250 plus $100 cost assessment. And the officer is Jose Perez.
So item 17. Go ahead.
Officer Perez of the City of North Miami, today we're hearing the case in regards to the property at 1685 Northeast 124th Street. This property was originally cited in November 2021. They have previously been found guilty, and as my February inspection, they have not obtained their business tax receipt. The property was posted and sent via certified mail on November 22nd, 2022, and it's time the city is asking for the fines to be ratified.
Based on the testimony of the city's code compliance officer, the photographs and the evidence presented, not photographs, I didn't see photographs, showing that the property has been out of compliance since the abatement date of December 2nd. I find in favor of the city and ratify the fines approved to date in the amount of $250 plus $100 cost assessment. The said fines shall continue to run on a daily basis until there is compliance.
Case number 18, Officer Perez of the City of North Miami. Today we're hearing the case in regards to the property at 1685 Northeast 124th Street. This one is for a certificate of use. At this point in time, the case was already found adjudicated, so they're found guilty. As of my final reinspection, they had not complied. The property was posted and sent via certified mail for the hearing on November 22nd, 2022. And at this time, the city is requesting the fines be ratified.
Based on the testimony of the city's code compliance officer and the evidence presented, reflecting that the property has been out of compliance since the abatement date of December 2nd, I find in favor of the city, hereby ratify the fines accrued to date in the amount of $250 and assess costs in favor of the city. The said fines shall continue to run on a daily basis until there is compliance.
Item number 19, Green Acres Park LLC, case number CEMIS 2021-00044. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $250 plus $100 cost assessment. The officer is Jose Perez.
Officer Perez of the City of North Miami.
Officer Perez, before you start, when I reviewed this particular file, it seems as though somebody made a mistake and introduced the backup materials from the prior case into this case. So there was really no backup to number 19. It was just the exhibits used for number 18 were put into 19. You follow what I'm saying?
Viewing the file here, I see what you're saying. Yes. Yes.
Yeah.
So the evidence,
So
unfortunately, that was uploaded is for the incorrect case.
Yeah, it was the wrong exhibits, but nonetheless, I remember this case very well from the last time. The only question that I had, because I've never really reviewed Chapter 11, where these guidelines come from. You know, if you or the city attorney would please send that to me, because it's important for me to know what those guidelines are and where the violations occur. There are certain preemptions in Florida law that prohibit cities from regulating shopping carts. So I want to make sure going forward that when we apply these regulations, that they're consistent with Florida law.
Definitely.
Okay. So if you want to go ahead and you know, tell me what the status of this case is.
Well, at this point in time, since the wrong evidence is uploaded, we're going to go ahead and table it. We don't want to have any issues or discrepancies, so we want to be very transparent in our cases. So we're going to go ahead and table it, and when we bring it back before you, I'll also have the definitions and the section of this ordinance uploaded so you can review as well.
Yeah, considering that it's Home Depot and they have a battery of lawyers, I want to make sure that we do things right. So give me the right backup if you have pictures. And also the guidelines would be very helpful. And perhaps the city attorney can review those guidelines in the meantime to make sure that they are not preempted by Florida law, which governs shopping carts.
Will do. Jose, if you don't mind including me in the email where you send all the exhibits to the magistrate, that'd be super helpful. Or send it to me separately, whatever you want to do.
No problem.
Thank you.
Okay, next.
Item number 20, Gumo Corporation, case number CEBPR 2022-00390. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $250 plus $100 cost assessment. And the officer is Aaron Barber.
Aaron Barber, City of North Miami Code Compliance. As noted, this case has been previously adjudicated. Notices were posted at the property as well as mailed certified. And as of this morning, December 15th, there's been no compliance. No applications have been made. No building permits have been applied for.
Okay. This was one of my cases heard on October 20th or thereabouts. Based on the testimony of the city's code compliance officer, which is unrebutted, the photographs and other evidence presented that the property has been out of compliance since the abatement date of December 2nd, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $250 and assess costs in the amount of $100. The fine shall continue to run on a daily basis until there is compliance.
Thank you.
Item number 22, Jean Narcissus and Berlinda. Case number is CEBPR 2022-00420. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $500 plus $100 cost assessment. And the officer is Aaron Barber.
Aaron Barber, City of North Miami Code Compliance. This is a case for a fence installed without permit. Notices were both mailed, certified, and posted at the property. And as of this morning, 12:15, there have been no permits applied for, no compliance for this property.
Based on the unrebutted testimony of the city's code compliance officer, the photographs that I've reviewed and other evidence presented that the property has been out of compliance since the abatement date of December 2nd. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 plus $100 in costs. The said fine shall continue to run on a daily basis until there is compliance.
Thank you.
Item number 26, KISS and KISS, case number CEDCU 2022-00415. This case was actually in compliance, so I'm just going to I was just reading into the record, so it's dismissed. Magistrate.
Are you done?
Yes, I'm going to go ahead and proceed with the next item, with item number 28. It says
no, 20. What happened with 26?
It's in compliance. It's closed in the system.
Okay, all right. We go to 28 now?
Yes, we're going to go to number 28, which is Marquez Property Holdings, LLC. Case number CEFLR 2022-00235. Any officer is Tamara Petit.
Good afternoon. Code Compliance Officer Tamara Petit with North Miami. The property address is 13200 Northeast 6th Avenue. And on April 25th, 2022, they were found in a sense of not having their business tax receipt. This is a new case, and during the final reinspection on December 2nd, they did not have any application on file, and I did go ahead and check today, and they still did not have an application on file.
What kind of a business is it?
It's a housing area, so they need a business tax receipt. It's apartments.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Item number 30, we have Ocean Air Management, LLC. Case number CEFLR 2022-00213. Any officers, Tamara Petit.
Good afternoon, Code Compliance Officer Tamara Petit with North Miami. This is also a new case for the address of 12357 West Dixie Highway. On April 18, 2022, it was shown that they didn't have a business tax receipt. And during the final reinspection on December 2nd, they did not have an application on file.
This is the Lotus House?
Yes.
Okay. Isn't this a nonprofit organization that addresses child abuse and domestic violence and those kind of things? Is that the same one?
No.
Okay, because there's a Lotus House downtown that does that. Okay.
Are you sure, Tamara?
This one is a recovery center. It's not the same with downtown because the downtown one wouldn't necessarily. It's not the same. I looked.
Okay. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists and the proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Item number 32, Rosenthal SSR LLP. Case number CEFOB 2022-00183. This case was previously found guilty with an abatement date of December 2nd, 2022. Fine was set at $500 plus $100 cost assessment, and the officer is Jose Perez.
Officer Perez of the City of North Miami. Today we're hearing the case in regards to the property at 14095 West Dixie Highway, specifically the Solution Barbershop Inc. Unfortunately, they were cited back in April 2022 for not obtaining a business tax receipt and was found guilty. As my final reinspection, unfortunately, they have not obtained a business tax receipt. The property was posted on November 22nd, 2022, and was also sent via certified mail on November 22nd, 2022, for the notice to appear. And at this point in time, the city is asking for the fines to be ratified.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the property has been out of compliance since the abatement date of December 2nd, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $500 per day and assess costs in favor of the city. The fine shall continue to run on a daily basis until there is compliance.
Item number 36 and 37, the Monterey Apartments LLC. Case number is CEFOB 2022-00223. And item number 37, case number is CEZCU 2022-00.
Let's hear 36 first.
Officer Perez of the City of North Miami. Today we're hearing the case in regards to the property at 575 Northeast 143rd Street. This is an apartment complex under the name of the Monterey Apartments LLC. They were cited back in April of 2022 for not obtaining a business tax receipt. As of my reinspection, which was on Monday, May 23rd, 2022, they had not obtained a business tax receipt. Therefore, the case was filed for a hearing. The property owner and the registered agent were notified via certified mail. And for this hearing, they were served on November 22nd, 2022 via certified mail and by posting. At this point in time, they still do not have a business tax receipt, and the city is asking for an adjudication as well as a monetary fine.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. I'm showing a manager agent by the name of Gideon Friedman in New York. Apparently it's a New York company, and probably would recommend to you that you also send the corporate headquarters a copy of the order.
Not a problem.
And the order goes for both violations, correct?
I'm sorry.
Your ruling is for both violations?
You're coming in garbled.
The ruling, is it for both violations?
No, that ruling is for the first one. Now we're going to hear the second one.
No problem.
Item number 37, Officer Perez of the City of North Miami. Today we're hearing the case in regards to the property at 575 Northeast 143rd Street. Again, this is a apartment complex that is being rented out, being run under the Monterey Apartments LLC. Same parameters as the previous case. They were cited back in April 2022. They had a reinspection date of May 23rd, 2022, where unfortunately they did not obtain their certificate of use. As of that point, the case was failed for hearing. They were notified via certified mail to the registered agents, and they were notified for the hearing on November 22nd, 2022. And as of my final reinspection in December, unfortunately, they did not obtain a certificate of usage. So at this point in time, the city is seeking an adjudication as well as a monetary fine.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice having been given, I find in favor of the city, enter an adjudication and set a compliance date of 30 days. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Item number 38 and 39, Venus Park 26 LLC, case number CFOB 2022-00376. And item number 39, case number CZCU 2022-00343. This case was previously found guilty with an abatement date of December 2nd, 2022. and the magistrate ordered the $100 cost assessment owners, and the officer is Shannon Sanders.
So on 38, there has not been an adjudication. On 39, yes.
Yes, only the $100 cost assessment was ordered.
Well, the number 38 is a new case.
Yes.
Okay.
Special Magistrate, both cases have been have met compliance. I received an email from Community Planning Development stating that they obtained their certificate of use yesterday and their business tax receipt this morning. So in lieu of that email, I want these cases to be marked as dismissed. They had applied months prior, so it was more or less the city's holding them up from obtaining those certificate if not documents. So again, those both cases for the CU and the business tax receipt have met compliance.
Very good. Excellent. Responsible owner happens to live on Golden Beach. Good things happen in Golden Beach. I don't think there are any poor people there. So I'm sure that he could afford it.
That concludes our agenda for today, Magistrate.
Thank you very much. So we stand adjourned.
We stand adjourned. Thank you.
Okay.
And have a happy holiday.
You as well, all of you.
Happy holiday. Bye, everyone.
Bye.
Have a good one.
All right. Happy holidays.
Recording stopped.
Bye, Mark.
Okay.